Hello. Great news. I have a little bit of a cold, so my that's why I was so grumbly yesterday. It's because I have a cold. So I will be proceeding with a cold voice. And that's okay. Michael Haynes, I have not seen you in a long time and I miss you. How are you, darling? It's good to see you. All right. We're just gonna chill. Like this is gonna be a chill vibe. Hi, Oomph. We're just gonna chill a little bit, and Gal will be joining me, and certainly others who shall not be named know they're invited as well, if they so choose. Up to them. And we'll also be reviewing using as one of our props. One of our visual effects will be Oomp's actual thread on the state's brief, and also Oomph got his hands on the Eastman response, or brief rather, the Eastman camp. So we haven't read that yet, but it should be really interesting. Hi, GP, how are you? Good to see you. Good to see you. Anyway, so I'll just wait till Gal gets here. But let me go ahead and pull up. We got a lot of stuff. A lot of stuff to share. It will be amazing. All right. And let me make this a little bigger. Oops. Whoops. There we go. It's not interesting. Well, and that's it just recapitulates Eastman's case in chief. Well, I think it's and that you're right. That is not terribly interesting, but it is absurdly. There you go. That was actually the reaction when I shared it with Gal. That was the reaction she had, which is that this should be funny. So absurdity rules the day, I think. So no worries, Michael. No worries. I know you've been busy. It's okay. I've been busy too. Everybody's been busy. It's just one of those things. It's the way things happen. But it's going to be okay, I think. All right. So I'm going to start a little bit going through kind of what brought us here. So if you know, or if you don't know, or if you're just joining us, John Eastman, who is one of the, or if not the architect of multiple schemes, including fake electors as well, for keeping Trump in power. I miss you too, Michael. Oh, yay. Oh, good. Well, I won't be on camera today only because I have a cold and I look like I have a cold. So I'm in my full, I have a cold mode. But Mr. Eastman, who is a lawyer, barred in California, was a very integral part of all of these schemes that people are now facing the music for. Notably, Ken Cheesebro. Ken Cheesebro was a friend of Eastman's, although he claims not to know him now. Eastman claims not to know Cheesebro. very well. But fun fact, they are really actually pretty good friends. And so I think Mr. Eastman's getting a little scared. Hi, basket package. I think he's getting a little scared. So Mr. Eastman, as the architect, my 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 weird observation of John Eastman is that he has fancied himself a constitutional great mind for many, many decades. And he has this fever dream of testing constitutional theories. And I believe that his participation in this not only comes from his desire to lick the boots of autocrats and be noticed, but also to try and push the limits of the Constitution. And actually not even push the limits, just like run through them. And by that I mean run through them. So I think this was a vanity project for him, and I also truly believe that one of the unintended consequences of the right-wing media system is that they got the people who went through that right-wing media system got so confident in their storylines. Thank you, Algo Tickler. Oh, sorry. No, no, I'm so sorry. It's my I was just wondering if you yeah, I didn't want to make sure you're here. Okay, I'm gonna do it right now. Um, there you go. The the they believe that because they get such good response from the right wing kind of media audience that they cater to or pander to, I should say, that that means that they actually have some viability in the real world. And so the unintended consequence of that right wing media system that is so fabricated is that the courts aren't buying it. And so Eastman, I think, is one of the first real, well, of course, the New York case around his finances, but around the crimes committed surrounding January 6th. Yeah, the Kool-Aid to disbarred pipeline. Oh man, this is it. That's yeah, the Kool-Aid. I really truly believe that. I really truly believe there's at least a segment of those people, the Eastmans, etc., who believe that because people reinforced their fucked up ideas about democracy the last few, whatever many years, that actually was going to play when they tried to actually break the law in its name. And it's not. So, I mean, really. Yeah. All right. So I'm going to do, let's see, I'm going to have to do a little switching back and forth because the document is so good. All right. Well, let's just start as Gal, if you got the link, it's in the chat. I hope I'm in everything. Am I in everything? Oh yeah, there's democracy done. Okay. So the state bar, what Oomph did, this is his Twitter, is look at the state bar closing brief in the matter of John Eastman. So it was the brief that really outlined the case against John Eastman to disbar him from the state of California. And fun fact, it's probably going to happen, and it's probably going to happen soon. And all of the data from this case is going to be handed over to the special counsel and everyone else. So exciting. Oh my God, exciting. All right, count 1, failed to support the Constitution. Counts 2 and 4, misleading a judicial officer. Good morning, GP. Good morning, Art Music. Counts 3, 5, 6, 7, 8, 9, misrepresentations, subcategories of moral turpitude. Counts 10 and 11, moral turpitude. Aggravating is multiple acts, acting in bad faith, significant harm. See page 70. Indifference, lack of candor. Oh my God, it's so true. Mitigating, lack of prior discipline and distinguished career. Exactly. Exactly. Ooh, you have Putin. Awesome. Let's see. So page 70, okay, so we're actually gonna go through the document because there's a couple things in it that are like super funny. Okay, hold on. This brief, better final better, final determination of the court and the Colorado Crew decision together solidly provide J6 sequence of events with pretty well established facts. Oh, really good. And then this is the link to where the document is. So I've retweeted this, but I will put a link to this. So Oomph highlights a section here. Respondent's conduct harmed and continues to harm the nation using his reputation as an expert constitutional attorney. He made repeated false statements that he successfully intended to subvert and cause distrust of the 2020 presidential election and of local election officials. His tactics predictably contributed to officials receiving threats of harm. He demonstrably contributed to the gravest threat to our democracy in modern history, the violent attack on the Capitol on January 6, 2021. Respondent's repeated unlawful conduct, the harm it caused, and its predictable continued injury to our democracy require his disbarment. I mean, there you go. Boom, mic drop. Boom, mic drop. Oh, there she is. Sorry, gal. Yay. Welcome. You're muted.
Oop, I had to find my button. Yeah.
Find my button. Yeah.
Well, it's weird.
Yeah.
Oop, shit. I'm dropping shit now.
No, here we go.
I don't know how you do this. I'm like never
I
prepared.
don't.
You're the woman of the hour, every hour. Yeah, I have to, like, on my phone, I have to do, when I open this, because it goes to a browser, I have to, like, change it from, like, a mobile device view to, like, a desktop view in order to, like, find the mute button. It's very weird.
God,
You can't,
that's
it's not a
weird.
really, it's not a really
Not
good
conducive.
thing for, like, if you're on your phone. It's better if you're on
Oh,
a
you know what,
computer.
though? There is a StreamYard app that you could download to be a guest.
Oh,
Oh,
maybe I
yeah.
can do
I just found
that.
that. Yeah.
I'm gonna find, I don't
Anyway,
know if I can see. I don't know if I can leave the page. I'll test it. I may
no
be
worries.
here. I may be back.
Yeah.
Okay.
This is our
Where are you
laboratory.
at? Are you
I just
pulling up the
started.
whole
I just
document
started. I am
or?
gonna pull up the whole document. I was just gonna run through Oomph's kind of highlights, and
Oh
then
yeah,
I
those are
thought
good.
we'd go through the document, and then, because I started reading it, and then I fell asleep, and then I started, and then I fell asleep. But it is very good. And then we haven't even touched Eastman's response, which,
It's gonna be so
Oomph
funny.
it is gonna be funny. Oomph said it's basically just a restatement of his case, which is fine because that in and of itself is hilarious. So, here we go. But yeah, I was just starting off really, and I love the highlight that Oomph has on the screen in his tweet, respondent's conduct harmed and continues to harm. I mean, this is just like a boop. That's what happened. This is a very good brief. This is a very good brief. All right. Let me go back to the tweet. We're going to do this. So you can be looking for these things when we go through the actual document. All right. And then this section he highlights the pattern occurred repeatedly over the course of the trial. Oh my God. Respondent casting aside judicial decisions that analyze the very claims he and his allies were raising with which he disagreed, either citing non-binding dissents or claiming that the fact that the decisions were not rulings on the merits justified casting them aside. He was a petulant child this entire case. He was a baby. Let's see. It's his willingness to do this is striking given his status as an officer of the court, the central role the courts play in resolving election disputes, and the time and energy courts devoted to the election challengers, which he was part of the Bush v. Gore case, He was part of the Bush team. Yeah. He's a knucklehead. Let's see. Let me come back here. Whoops. Let's see. All right. Let's see. Technical issues based on the substantial compliance doctrine ignores the important values that Latch's rule. I probably said that wrong. And the substantial compliance doctrine serve in the election context. As the Wisconsin Supreme Court explained regarding the Latch's doctrine when rejecting Trump's effort to overturn that state's results, the longstanding and well-settled doctrine has particular import in the election context, allowing late-filed challenges to votes cast in reliance would disenfranchise voters. So this is the other piece. The remedy that Eastman and others purported was to disenfranchise voters because in many cases, they believed that since the state changed, or people in the state changed how elections may run in terms of drop boxes or whatever, just because those were quote unquote illegal as determined by state legislatures, that should mean that all of the votes cast under those should be just disregarded. Now, in what universe would that ever be fair? If you just took that, right? Latches for nerds, disregarding court's decisions. Yeah. So, yeah, it's crazy. It's crazy. Let's see. Oh, wait, here we go. What is this one? Later that night at 9:32, respondent, who is John Eastman, emailed Jacob proclaiming major new development attached. This is huge, as it now looks like Pennsylvania legislature will vote to recertify its electors if Vice President Pence implements the plan we discussed. Here's the other thing. Oh, that Jacob is one of Pence's lawyers. So he said under oath on the stand in this disbarment hearing multiple times, I believe, that he never told Mike Pence to reject the electors. But there's actual testimony from, I think, Jacob and maybe Mark Short and maybe Pence, I don't even know, that he did. Like, how do you do that? At 9:54 p.m., and this is what? January, I don't know what date this is. It's probably like January 4th or 5th. Let's see. Just 2 minutes later at 10, Trump tweeted, "If Vice President Mike Pence comes through for us, we will win the presidency." Many states wanted to certify the mistake they made in certifying incorrect and even fraudulent numbers in a process not approved by their state legislatures, which it must be. Mike can send it back. He just lied. He just lied. January 5th. Thank you. He lied over and over and over again. Over and over and over again. I mean, it's just, that's why I got so, and all of us who watch this trial, it's so exciting. Or hearing. It's not a trial. It was a hearing. No state legislator was planning to yeah, as demonstrated above. Oops. Also knew that okay, sorry. I'm not even, I'm so excited about this. Moral turpitude and manifest dishonesty. Moral turpitude, section 6106. Moral turpitude has been defined as, quote, everything done contrary to justice, honesty, modesty, or good morals. Acts of deceit designed to subvert the free electoral process constitute moral turpitude. Well, I mean, hello, then why are they allowed to get away with saying this isn't an act of moral turpitude in Georgia? The concept of moral turpitude also depends on the degree of public harm produced by the act in question. Gal, interrupt any time. I'm just going through, so no process here. Dishonesty in the profession has long been a basis for attorney discipline. Yeah, I mean, really, come on now. This is, I mean, and I'm glad they go through it, because everyone deserves their day, and he got certainly a great opportunity to defend himself. He just chose to tell the truth, which meant that or lie rather, which means that he didn't defend himself. He just made himself look more obvious. Signature harm to client. Oh, significant. Sorry. Harm to client, public, administration of justice. I'm pretty proud of myself for getting all those. I'm so sorry. Their harm from respondents' misconduct is immeasurable and deserving of the most significant aggravating weight, and not least because it contributed to the January 6th violent attack on the Capitol. But the harmful impact of respondents' misconduct on our democratic institution goes well beyond the attack on the Capitol. Documents and testimony from multiple current and former state election officials show the harm on the election that the election lies respondent peddled and continues to peddle caused to the institution they serve and on them personally. Listen, Doug Frank, when do we get down to those guys? They have had to expend resources to respond to counter rampant disinfo, increase security, conduct audits, address the erosion of trust. Yeah, this is, wow. This is great. What a great okay, here we go. Now we're getting some good stuff. We got some markups here. Indifference. Respondent has not accepted an iota of responsibility for his misconduct. He shows a callous indifference to the harm he's caused and does not appear to have any remorse whatsoever, which is true. Which is true. Likening his statements to the ellipse on January 6 to shouting fire in a theater and claiming the risk of people getting hurt was justified. Respondent admitting he gave no consideration of the effect on the crowd of his ellipse statements. Instead of accepting responsibility, respondent has attacked the state bar and characterized this proceeding as political persecution. Moreover, it's clear that respondent has no regrets about his attempts to overturn the 2020 presidential election or its effect on the election officials and workers who run the elections. Even during the pendency of this proceeding. Yeah, he really has. Respondent has continued to promote in media interviews the outlandish and long debunked conspiracy theory about State Farm Arena election workers. Respondent is wholly indifferent to the truth on any issue in this case, no matter what the countervailing
That's a
evidence is put before
nice
him
way to put it. That's kind of her.
on any issue.
You're not just a fucking liar. You're
You're just a
indifferent to the
big
truth.
motherfucker. Yeah, exactly. And that, sir, is another reason we can't stand you. Complete and total lack of remorse, complete repeated disregard for the truth, facts contrary to his desired position, and stated contempt for these disciplinary proceedings all necessitate disbarment. Lack of candor, whoopsie. Much of respondent's testimony was evasive and inconsistent and replete with convenient memory lapses and his unwillingness to answer simple yes or no questions. It's true. Where's the lie? Including whether he believed there was an outcome determinative fraud in the 7 states he contested. He wouldn't. Oh. He was untruthful about numerous critical issues in this matter, including that he urged Pence to unilaterally reject certified slates of electors and about his testimony before the Georgia State Senate subcommittee. Okay, listen. That one's just the introduction. You guys are funny. Okay, here's the other thing. Let me go ahead and come back here. Thank you, Oomph. That was amazing. I love that. So here's the funny thing. Oops. Like, he lied. That was one thing I noticed when I was reading it. He lied, or he did not tell the Georgia state legislators that he was testifying in front of that he was in fact part of the working for the Trump campaign. He literally did that. And like in December of 2020, not like, oh, it was August 2020. Oh, thanks, Higgins. I'm so glad. It sounds good. I think I might have figured that out. But yeah, it's just terrible. Like this guy is just too much. He's too much. He's too much. He's too much. If Jesus is on your side, regrets are nonsense. That's right. Hassan and Jim were somebody Clark's story. Yeah.
You should yeah. I can probably go find it, but like if I leave the screen I can't hear anything. It's very strange.
Oh, okay.
And also there's not an Android app for that. So
oh God.
So there's that. But anyways, it doesn't matter. If you go to Foggy's Twitter page, he clipped out like Eastman's hearing in front of the Florida state legislature. I think it was like back in 2000. And it's just really interesting to, to see. That's like what, 24 years ago, 23 years ago. Wow. So, and it's literally the same, almost the same exact plan and concept that he's literally presenting in 2000.
And wait, is that it? You said that's on Fox Twitter?
Yeah.
Clearing the fog. Okay. All right. I'm going to, I want to do that. Let's do that.
I can go find it. It just won't be able to hear you for a second.
All right. No worries. I'm going to start up on this piece of crap. Or no, this is the good one. The other one's a piece of crap. All right. So this, my friends, thank you. This was the State Bar briefs. This is what we were reading from. This is something that Oomph took a look at and did that. So this is that. This is the document, which I'll link all of these documents so that everyone can look at them themselves after the fact. But it's meaty and there's a lot, but we can kind of skip through it and see what other things hit us in the side of the face, and then we'll go from there. Oh my god, it's just so good. Look at this. Look. Okay, wait. I'm sorry. Let's just go back. Respondent conspired with Donald Trump and others to obstruct the January 6th joint session of Congress. So all of this, blur, 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 ignored evidence, sought to support his fraud claims, claims regarding illegal conduct, da 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 da. It goes through all of that. All of that. All the bullshit crap that they continue to throw up as possible reasons that Mike Pence could have overturned the election. No, none of them work. They've been argued multiple times. Blah, blah, blah. All right. So then this is the, oh my God, January 2nd, 2021, culpability, aggravating misconduct. And I don't know when he did. I watched a, because he's part of the Claremont Institute. So, or no, sorry. Oh no, it was Claremont. Anyway, I was watching the Tom. Is this Finkelstein or Finkel? I don't know what his last name. I can't remember his last name, but the guy who's the head of the Claremont Institute was interviewing John Eastman. I think that was last year. It might have been. I'll have to check. Anyway, it's a 3-part interview, and it basically is, like an MTV confessional.
Klingenstein. It's Tom Klingenstein.
Klingenstein.
It was this year.
That's it.
It was just a
Yeah.
few months
Oh,
ago.
it was this year. Yeah. Okay.
Yeah. Yep.
Is that on here? Is that on here? I mean, did anybody? I didn't hear them bring that up, but anyway, doesn't matter. Okay. So the introduction, this is what Oomph had done some highlights on. So the timeline. 35 days of trial, 23 witnesses, more than 400 exhibits that show John Eastman is culpable of all charges, etc., to illegally disrupt the peaceful transfer of power, blah, blah, blah. By mid-December, courts in the 7 key states had uniformly rejected. All right? But no, that wasn't good enough. No, I'm sorry. Let's see. The road is 23rd and January. Okay. A lot of argument about this memorandum that he wrote. He started it on December 23rd, and I guess the final version of it was January 3rd. There was a ton of argument about whether the draft was it was just stupid. It was all flim flam. It was like trying to just totally confuse the issue. But this lays it out more clearly. He knew that there could be no true dispute about who had won the election. Nonetheless, he proposed in those memos and in his communications with Trump, Pence, and Greg Jacob that Pence should unilaterally refuse to count or delay counting 7 properly certified states. My God, I fucking Respondent knew that this strategy had no support in law or historical precedent, even as he claimed just the opposite in his memos. Fortunately, Pence knew it too. And even more fortunately, he called, of all people, Dan Quayle. Who knew? Dan Quayle told him it too. Let's see. A good faith effort. There was something where he purposely parroted amendment. Let's see. Oh, here we go. Whoops.
And
John
while
Yoo.
I'm talking to you today, I am
Yes.
headed to the post office to put something in the mail for you. So.
Oh, thank you.
I know,
That's
it's
exciting.
gonna be fun.
Yay. Thank you.
Yeah, John Yoo is interesting too. So I'll have to pull up
I want to.
my thread on him. He was involved in 2000 also, the Bush v. Gore stuff.
Oh, right, exactly. And wasn't he on the other? Wasn't one of them? Or no, Cheesebro.
Cheesebro was, I think, was with Gore. Yeah.
Gore, yeah. Cheesebro was on the Gore side, but that's also where Eastman and Cheesebro met up.
Well,
So,
John
yeah.
Yoo was a Bush guy, and
Mhm.
he's the one who justified the torture.
Right. Right.
He wrote the torture memo.
Yes. John Yoo is a terrible person. Here we go. We're going to talk. So now let's jump into the kind of the meat of some of the case. Respondent conspired with Donald Trump to obstruct. Respondent own expert professor John Yoo testified that President Biden won the election fair and square. He did multiple times. He said that on the stand. The certificates of ascertainment in the key states uniformly confirmed the election. Multiple recounts and audits. Antrim County, Michigan, Georgia, recounts in Arizona and Wisconsin. Even the cyber ninjas said, we found a few more votes for Biden. So they couldn't even spin it. Notice you don't see Doug Logan anywhere these days. Let's see. Further confirm the results. Multiple state election officials who testified in the proceeding explained in detail. That's right. The There were, oh god, I can't even think. Let's see. As shown by the chronology below, in early December, the strategy involved asking state legislatures and courts to decertify the election using false and misleading claims that the election's outcome had been altered by fraud and illegal conduct by election officials. And the when pushed on the evidence, it was always affidavits, but he couldn't, there was always like he was one step away from the affidavit, so he didn't have to like confirm that it was absolutely true, but that's yet formed the basis of some of his legal argument. So it just pulled the curtain back so brightly on what some of the inner workings of trying to overturn the election were. Okay, by mid-December, after the Supreme Court, remember, had shut down efforts to decertify the election in Georgia, Michigan, Pennsylvania, and Wisconsin, after the Electoral College voted on December 14th, and after Republican leadership in the Senate had confirmed Biden's win, eliminating any chance that Congress would overturn the election, the strategy grew even more lawless, culminating in a proposal to Vice President Pence as president of the Senate to override the ECA, the Electoral Count Act, and the contrary determinations of state executives, state and federal courts, federal executive agencies, both houses of Congress, by unilaterally rejecting the Biden electoral slates from the 7 states, or delaying their count at the January 6th joint session of Congress, in effect setting up Pence as the unreviewable ultimate arbiter of the question whether he and Trump had won the election. Oh, thank you. Oomph, I just got that link. Let's see, the strategy, the legal framework for which Pence's counsel described as essentially entirely made up was wholly unsupported by facts. All right. According to you, Pence was on unassailable grounds. That's a quote when he rejected the plan. And this is John Yoo. I'm going to remind you again, is John Eastman's witness, which it was obvious lacked merit. Nevertheless, throughout this proceeding and in the face of clear and convincing evidence of his misconduct, respondent has sought to pervert and sidestep the evidence of his dishonesty and blah, blah, blah. This is my favorite. December 3rd, respondent testified before the Georgia Senate Judiciary Committee where he urged them to certify the electors certified by Governor Kemp and instead to certify a Trump slate prior to December 14th. Although respondent was testifying in furtherance of his representation of Trump, he did not disclose that fact, introducing himself only as a constitutional scholar. He lied. He lied. That's a misrepresentation. He urged the Georgia Senate to disregard the popular vote and pick its own slate of electors. As grounds for this breathtaking request, he claimed the election had been tainted by rampant evidence of fraud and illegal conduct by Georgia election officials. He claimed Georgia election officials allowed as many as 2,500, this is a good part, stick with me, as many as 2,500 convicted and still incarcerated felons to register to vote and cast votes in the election, which were then illegally counted. More than 66,000 underage individuals to cast ballots, which were then counted. At least 2,423 individuals to vote who were not listed in the state's records as having been registered to vote. more than 1,000 voters who had registered at a post office box to cast ballots and have those ballots counted, and more than 10,000 such deceased individuals' votes to be counted. In his oral testimony, he proclaimed the existence of rampant fraud and again claimed that up to approximately 66,000 underage individuals were illegally allowed to register to vote and 2,500 felons were illegally allowed to vote. Oh boy, here we go. Here we go. Respondent knew or was willfully blind to the fact that these allegations were false and misleading. The figures respondent cited were from an affidavit respondent received just before he testified. The affidavit of Brian Giels, which was appended to the Trump campaign's filing the next day in Trump v. Raffensperger. As of December 3rd, 2020, the day respondent testified in Georgia, respondent had never met with or spoken with Giels, a CPA whose affidavit reflected no expertise in statistics, election administration, or political science, and which disclosed the potential for false positives due to data limitations, a fact of which respondent acknowledges he was aware at the time. Nonetheless, respondent concluded the affidavit, quote, looked credible, despite not showing it to anyone with relevant experience or taking any meaningful steps to assess its reliability. At trial, the State Bar presented respondent with the Georgia Secretary of State's official responses to these numbers, namely that 4 voters, all of whom turned 18 prior to the November 3rd election, requested a ballot prior to turning 18, not up to approximately 66,000. Or more than 66,000, as respondent claimed in his oral and written testimony, respectively. That 2 potentially deceased individuals voted, not more than 10,000, as respondent claimed in his written testimony. That 0 individuals voted who were not listed in the state's records as having been registered to vote, not at least 2,423, as respondent claimed in his written testimony. That up to 74 potential felons voted, not 2,500 or as many as 2,500 as respondent claimed in his oral and written testimony, respectively, and that many of the addresses alleged to the P.O. boxes were just apartments. When confronted with the state's responses and Giels' subsequently adjusted numbers, respondent defended his statements, contending they were all prefaced by caveats like up to and as many as, and that I think make them all true. These contentions are patently false. Multiple statements were, in fact, prefaced by more than or at least and exemplify respondent's dishonesty. That's my favorite part. That's my favorite part. I love that part. I love that part. I'm going to come back here. I miss you guys. I miss you. Oh, it's just he is moderating because we can't see him if he's not a moderator. It's weird. It's so weird. All from the ghost buses. I know. This is crazy. This is crazy. Oh, I you know what I didn't do? I didn't reach out to Joe Dempsey. Someone should reach out to Joe. I bet you he has some really hilarious comments on this. All right, let's go back to the crap. Back to the crap. Go, why, Luigi? Hold on. Sorry. Whoopsie. Oopsie. Wait, where am I? Where's my window? Where's my window? Where's my window?
What are we doing?
I don't know what we're doing. Where am I back? Where am I? No, I'm back. I just have to find my window again. And you do. Oh, here it is. Okay. So I just went through his when he was slammed down with the Georgia numbers, where he had testified to certain numbers from the Brian Giels affidavit,
Oh,
which
right.
had been given to him minutes before he testified in Georgia. He never met him. He didn't know anything about it. He just used the numbers. So this was his, like this section, which it starts on page 17, is hilarious in terms of like, no, it wasn't 2,500. It was 0. No, it wasn't 66,000. It was 2. You know, like it was just a beautiful, like, boom, boom, boom. And
Jovan was there in Georgia too.
oh, was he? Oh,
Mm-hmm. Jovan.
Jovan's really busy doing Twitch streams to one viewer, who I think is him or his mom.
Oh, I
I
thought
don't
it
know.
was you.
It might be me. Actually, that's not true. You're right. It's me and his mom. No. Uh, oh my God, his mom doesn't even watch him. Oh, that's bad. Sorry, Jovan. Let's see. Here we go. Oh, and respondent two. Here's the intervention that he had in the Texas lawsuit. You remember that Ken Paxton trying to, you know, uh, first of all, kiss up to Orange Man. Second of all, save his own ball sack from being fried, which it's about to be. So it doesn't matter, Ken. Too bad. You just
He
made the
also, Ken
inevitable.
Paxton also admitted that, oh, what was it? I remember we got it for Ron Filipkowski, so I know it's on his Twitter. I'll have to find it. But Ken Paxton admitted on Bannon's show something about like stopping mail-in
Yes.
vote ballots going out to people
200.
who requested them
Yes.
or something.
Yes. I'm sorry. You're making me cough. I remember that. And that there were ballots that weren't counted. Wait. Sorry. Hold on.
I'm gonna find it.
Wait. Wasn't there something where there was like, well, in the end, if they had counted those ballots, Biden would have won the state? Didn't he say something like that? There was something weird about that. Now I can't remember. I gotta find that. Anyway, I hold on. I just have to get a little drink, a little beverage, coffee, coffee. I love you, coffee. Yes, I do.
I got it. I'm gonna put it in your
Sweet.
thing.
Oh
Okay.
yeah,
I put a
private
bunch in
chat.
the private,
Girl,
right?
I love you.
Yeah.
That's so
The
much.
bottom
That's sweet.
one, the Ron
Yeah.
Filipkowski one, is the one we were just talking about. If
Okay, let
you
me go. Let me go to that. Let me go to that. All right, let me share. Why isn't it letting me? Hold on. Sorry, kids. Hold on just a minute. Stop screen and then present. Here we go. Oh my God, I'm so sorry. Yikes. Here we go. I can.
Yeah, I think
Wait, hold on. Let's make sure you're loud enough. Oh, look at Bannon's hair. Oh, he looks so young.
it's with lots of money going into it. And just knowing that we had 12 losses that we had to win. And if we had lost one of them, like we lost Harris County, Trump won by 620,000 votes in Texas. Harris County mail-in ballots that they wanted to send out were 2.5 million. Those were all illegal, and we were able to stop every one of them. Had we not done that, we would have been in the very same situation. We would have been on election night. I was watching election night, and I knew when I saw what was happening in these other states that would have been Texas. We would have been in the same boat. We would have been one of those battleground states that they were counting votes in Harris County for 3 days, and Donald Trump would have lost the election. Lawsuits. We had him in Houston. We had him in San Antonio. We had him in Austin. We had him in the counties where you'd have the most liberal judges. And it was a concerted effort nationally.
Oops.
Yeah, I think it
Oh my God. Texas AG Ken Paxton said yesterday that if he hadn't been successful with lawsuits to block mail in ballots, Trump definitely would have lost the election in Texas. Oh, thanks, Ken. Thanks. Should I go to any of these others? Oh, wait, you have Clearing the Fog. Let me pull up Clearing the Fog.
It's up to you. I mean, I
no,
put
let
some
me.
interesting, like, we could go in timeline, like, if you want.
Yeah, I
The
would
one
like
at the
to.
top is Clearing. That's the old one. So it's
Okay.
up to you because it may, some of his language in there may come out in this one, like, so that it's familiarized, like that you'll hear that he's just kind of doing the same shtick.
Rehash.
But
Yeah.
I
Okay,
think the
good. Let's
next
do that.
one I sent, the gal one is, I think it's a video, and now I'm going from memory because I'm driving. It's a video from December 9th, and then the next clip is from December 10th, and then I think the
I can
next
pull them
one
up.
from Gal in there is like just a note about like him and McGinney.
Oh yeah,
McGinney.
yeah, and Cleta, right? He's a Cleta.
Oh,
Everybody's
Cleta
nice.
Guinea. Yeah, he's a
They're all
World Congress of Families. He's
right.
he was at that in Italy. He's just a fucking
He
bastard.
belongs to all the best clubs. All right, let's look at Clearing the Fog. Another great account, friend of ours. We love Foggy. Let's see. John Eastman is the father of the fraudulent. This is from April 15th, 2022. 20 years ago, before SCOTUS stepped in, the Florida GOP was planning to use it to nullify their citizens' votes if Al Gore won the election, and Eastman was helping them plan it. Let's see. I think that's just a picture. Okay. No, look how young he looks the same, actually. But, he's always looked old. As the 2000 election went into recounts in the state Supreme Court battles in Florida, the Republican Party was very concerned that Gore might win, and they threw the kitchen sink at stopping it. SCOTUS eventually stepped in, overriding the Florida Supreme Court to stop the count. But, oh my Lord, let's just see what we got in here. On December 8th, the Supreme Court ordered the Circuit Court of Leon County tabulate by hand 9,000 ballots, ordered the inclusion in the certified vote totals of 215 votes identified in Palm Beach. Let's see. The proceedings leading to the present controversy are discussed in some detail in our opinion, Bush v. Palm Beach. On November 8, 2000, the day following the presidential election, the Florida Division of Elections reported that petitioner Bush had received 2.9 million, margin of 1,784, 1/2%. Okay, well, that's the background on the complaint. The Florida Supreme Court held that Vice President Gore had satisfied his burden of proof with respect to his challenge to the Miami-Dade County's failure to tabulate by manual count 9,000 ballots on which the machines had failed to detect a vote for president undervotes. Noting the closeness of the election, the court explained that on this record there can be no question that there are legal votes within the 9,000 uncounted votes sufficient to place the results of this election in doubt. The Supreme Court also determined that the Palm Beach County and Miami-Dade County in their earlier manual recounts had identified a net gain of 215 and 168 legal votes, respectively, for Vice President Gore. I forgot I didn't forget about it, but I never really think about that as being, it just felt like a long drawn out process, not like it was so as dirty as this one. I don't know. I was younger then though. So there you go. If SCOTUS had not stepped in, the Florida Republican Party was preparing to invalidate the results of the election. On November 29th, they invited speakers to a hearing where they discussed the possibility of an alternate slate of electors. Where have you brought that before? Where have you heard that one? Let's see. November 29th, the Committee of Florida Lawmakers meets to consider whether to convene a special session of the state legislature to appoint electors on its own. Wow. November 29th hearing, citizens urged legislatures not to hold a special session. Several lawyers warned that the legislative selection of presidential electors would set a dangerous constitutional precedent. The GOP-controlled legislature saved the final word for John Eastman. Florida lawmakers vote along party lines to recommend a special session to name electors if the election contest is not resolved by December 12th. Eastman, when asked for his credentials to weigh in on the Electoral College, didn't need to be very convincing. The Electoral College is part of that structural foundation. That is the part of the underlying principle and theory of our whole constitutional system. All right, let's see what's going on here.
Works once these certificates. I've had several questions during the meeting yesterday and even this morning and all day yesterday and all day this morning about the Electoral College, how the Electoral College works once these certificates get up to Congress. And we went on a mission yesterday to find somebody who could be sort of qualified as a quote expert, if you will, in the Electoral College. And we have found someone, and he has come all the way from California, actually overnight, and has arrived here. And I'm going to introduce him and allow him to give us a presentation, and then we can ask some questions. Professor John C. Eastman is on the faculty of the Chapman University
Yeah,
School of
because
Law.
they
He
didn't
earned his
know him
JD from the University
beforehand.
of
He was just
Chicago
like,
and
yeah,
advanced in
I'll
government
be there
similar to
overnight.
wow.
Like,
with fields of
Who's this
concentration in
guy?
political philosophy, American government, and con law. He served clerkships in the U.S. Supreme Court, U.S. Court of Appeals for the Fourth Circuit, and he's currently the director of the Center for Constitutional Jurisprudence at the Claremont Institute in Claremont, California. Dr. Eastman, maybe you could inform the committee of how you become so qualified and an expert on the Electoral
How
College.
did you?
Thank you, Madam Chairman, members of the committee. I've spent the better part of my life studying the structural components of the Constitution. The litigation center that I run, in addition to my teaching obligations, files amicus briefs and conducts litigation primarily on structural constitutional issues, the powers of the federal Congress, and the Commerce Clause and the Spending Clause, those type of things. The Electoral College is part of that structural foundation that is part of the underlying principle and theory of our whole constitutional system.
I've had several questions during.
No. Okay, here we go. Here's his hard sell. After a lackluster introduction, Eastman begins his hard sell condescending to the lawmakers, explaining that this is uncharted territory and they must be nervous, but not to worry, because he was there to let them know that they were more powerful than the Supreme Court.
I think what we're going through here may be somewhat unsettling to you and to your colleagues in the legislature. Because we have grown accustomed, at least in this century, to having the courts provide the last answer for us on all matters of law and constitutional interpretation. But that's not the way the founders envisioned it in all cases. There are specific grants of power, not to courts, but to different bodies. To the Congress, we saw, to the Senate a couple years ago in the impeachment proceedings, that they serve as the court with no higher authority to reverse them. That's a plenary power. Here, the power delegated
plenary,
to you,
take a drink.
one is a plenary power.
Drink.
It knows no other appeal. It's just like before we had the 17th Amendment, your power as a legislature to choose the senators that would represent you in Congress. There was no other authority to counteract what you did. That power was given to you as a political body. It is a plenary power. And the fact of that power is specified in Article 2, Section 1, and has also been affirmed by the Supreme Court in the McPherson case. Now, I think it's important to keep that in mind as we go through these very technical statutory provisions, not ambiguous, but complicated statutory provisions, because in the backdrop of all of those provisions, Section 2, Section 5, Section 15, which I'm going to talk about in some detail today, is that plenary power. And we cannot view those congressional statutes as altering your plenary power that you have directly by the Constitution of the United States, because Congress cannot enact by statute something that limits the plenary powers of another body when those powers are drawn from the Constitution itself. So all of this discussion, Professor Ackerman's discussion on Section 2 and Section 5, all of those have to be read in light of the plenary power to you in Section 2, in Article 2, Section 1. Now, let me go.
Okay. Sure. Oops. No. Don't you dare. Interestingly, Eastman cited McPherson v. Blacker, implying that it provides precedent for everything that he was about to tell them that day. Of course, that isn't true. It didn't confirm plenary power, but that wasn't the argument he was there to make. This is the case. United States Supreme Court case, 1892, concerned a law passed in Michigan, which divided the state into separate congressional districts and awarded one of the state's electoral votes to the winner of each district. Suit was filed by several of these electors chosen in the 1892 election, including McPherson, against the Secretary of State of Michigan Blacker. It was the first Supreme Court case to consider whether certain methods of states' appointments of their electors were constitutional. The court, in a majority opinion, upheld Michigan's law and more generally gave state legislatures plenary power over how they appointed their electors. The court held that Article 2 of the United States Constitution also constrains the ability of each state to limit the ability of its state legislatures to decide how to appoint their electors. Wait, what? The suit was filed by several of these electors chosen I don't get it. Well, I think I get it. All right, I'll hold. While McPherson did affirm that state legislatures have full control, plenary power over how the state decides to choose its electors, it absolutely does not state that they can suddenly, oh, okay, I get it, and unilaterally decide to change those electors in the middle of an election. After the fraudulent elector scheme was attempted in 2020, this was clarified by multiple people, including the Republican House of Speaker of Arizona and the Attorney General of PA in SCOTUS filings. Oh, so Rusty Bowers addresses call for the legislature. Oh, I remember this. I remember this. Okay, wait. I remember that. Yeah, he did. And then this one was Pennsylvania. All right, here we go. Oh, this is the Rusty Bowers thing. Okay. I cannot and will not entertain a suggestion that we violate current law to change the outcome of a certified election. Rusty Bowers was pretty badass in this situation. I will say that. This week, Rudy Giuliani, Jenny Ellis, Jenna, with a breathtaking request that the Arizona legislature overturn the certified results of last month's election and deliver the state's electoral college votes to President Trump. Yeah, the rule of law forbids you to do that. Jeez, how hard is this? There's the state constitution. Or actually, I guess it's his little thing. Eastman's arguments to justify this scheme have no merit, and they never had any merit. Of course, he knew this even in 2000, which is why he used bluster and a barrage of confusing jargon. That's what I thought, in an attempt to pave the way for the scheme to proceed under color of authority. I like hearing.
Counted by Congress through what happens after the slate of electors or slates of electors that are certified meet on the 18th and send their votes to Congress. Congress is going to vote. That return must be counted by Congress, unless both the House and the Senate, meeting separately, concurrently reject that return, either because the votes were not regularly given by the electors, or because the electors were not lawfully certified. It is Congress, both houses, operating separately, concurrently can reject a single slate of electors if they view that those electors were not lawfully certified prior to Election Day, and reject that slate of electors certified. When there's determination in Section 5, this is after a contest, if the determination shall have been made, and you have the two components there, it has to be timely made and it has to be made in accordance with existing law. Two or more slates of electors both claim under Section 5. Suppose there's some ambiguity in this manner in which you have designated that contest provision go forward. The courts certify one slate, another executive official certifies another slate, both claim to be part of the Section 5 controversy or contest determination law. Again, it's Congress that has to make the determination on certifications up there, and none purport to be a Section 5 determination after a contest, right? Neither purporting to be after a contested election, but both initially. Electors
I don't get that.
appointed in accordance with your state law. Unless both houses decide, again, both houses decide that such votes are not the lawful votes of legally appointed electors. So in each of those multiple slate scenarios, Congress gets to judge on whether they are in compliance with your state law.
Huh. No, I don't think so. Eastman closed his blustery statement that day by forcefully telling the legislature that no one could stop them from what they wanted to do with their state electors because they had plenary judging ability in all matters election related.
And
Take a
if
drink.
there shall be any final determination under Section 5, then that slate is also communicated by the governor to the archivist. But note, the governor doesn't certify it. The governor just communicates that slate, right, to the archivist. And the certificate of such determination in form and manner as the same shall have been made. So if the courts, in accordance with your contest provisions, determine for themselves that after the contest there is another slate of electors, it's the court that certifies that. Now we have
What?
two competing certifications. One in accord with Section 5
And in
after
that
the
case,
contest
I get to
determination,
make the decision.
and another ab initio at the beginning after the initial appointment and final ascertainment in accordance with your law before the contest occurred. If either house of Congress disputes the legality of the final Section 5 determination and they do not agree, then the slate certified by the executive is the one that Congress shall count.
What?
That's the first one.
What
That's
is
the one
that?
made after the appointment of electors on November 7th, after the final
What?
ascertainment under your law on the 14th of November. That's the executive provision. That's
Where
Section
is
6.
that?
That's how we determine which is the executive certified slate and which is some other slate that is certified in accordance with a Section 5 contest. We get there only if the two houses in the Congress do not agree. That's the mechanism by which Congress has set out for itself how it will govern its counting obligations. But at each step of the way, it retains that judging ability, and it is answerable to no one, not the Supreme Court of the United States, not the Supreme Court of Florida, in that judging, because that power is delegated to it by the Constitution. That's the main structure, and I think that's the main piece that I hadn't heard yet, and I wanted to get out on the table, and I think I will leave it there and take any questions you might have.
So what this does, oh my God, people still have like subwoofers in their cars. Ugh, so
They do.
lame.
They do.
The 90s called, like they want, their fucking J&R audio back, whatever that shit is. Anyway, oh my God, like how dumb. You're like 40. Get over yourself. Anyway, so
Coming into his own. No, I know.
just put that big box in the back, make those put those subwoofers in there.
Yeah.
Okay, I do have to share a story. So when real quick,
Okay.
and then I'm gonna go back to what I was saying. The subwoofers
No
really
problem.
distracted me. But when I was in high school, because I was like a soccer player, and so like I'm short, and so I'm pretty strong. Anyway, there was this guy who had all these subwoofers in his truck or whatever, and he used to follow me around the parking lot in high school playing Sir Mix-a-Lot, Baby Got Back. With the sub, I swear. I'll never forget it, as you can tell. I certainly remember.
I love
Anyway,
it.
so,
I do love.
memories.
I love loud music. Yeah, memories. Memories.
Yeah. Anyways, what he just did in that clip right there is like if that was played in his hearing, and honestly it should be played in, in Jack Smith's case and Fonnie Willis's case, because essentially what he did there is explain a mechanism that that he tried to mimic in 2020, but didn't even meet his own threshold from 2000, because what they were trying to do, what he's saying there, which is get a court to certify as another slate of electors or whatever, right? But the second slate, the fake electors were never certified by anybody, not a court, not a governor, not anybody. So he's arguing in 2000 that you can do this as long as a court determines there was like outcome determinative fraud, or that the electors were appointed in a manner that was not, constitutionally sound. So the court would then certify the alternative or the contingent state of electors, and that all would be sent to the archivist, but only sent to the archivist if they were certified. And the ones that they sent in 2020 were never certified by anybody, not a court, not a governor, so nobody. So he literally had to bend his own theory for 2020. It just shows the lack of sound legal theory. It shows that he really was what did they call it? a plot in search of a legal theory, or
Right,
a coup in
exactly.
search
A
of a
coup
legal
in search of
theory.
a legal theory. Yeah.
He was trying to bend even his own, understanding of the Constitution that he had held for this long. I mean, that's how devious it was. It's so important to point out. I hope they show that clip
I
and
do,
talk
and
about that.
because that's the point, that his role in this, his planning and scheming, first of all, should reflect as poorly on Chapman and Claremont as it does. I mean, it should be louder about that. What are they pushing out? I hope that's the end of that story, is what are those people creating? And the fact that he I mean, everything he did is documentable, and he has no I really do hope that the importance of his role in creating this and fostering this throughout the Republican Party is one of the headlines that comes out. It's just, because that's the part that's
Yeah.
being taken for granted, is that you have people walking around as if they're normal human beings from the Claremont Institute, influencing policy and heritage, writing legislation. That's not
I
normal.
think if you pull up let's see,
Yeah.
in the private chat,
Yep.
I think it's the third Gal Suburban tweet. I
Okay.
think,
Let me pull up
it
that one and
is
see what it is.
in my
This is the National
estimation.
Humanities Medal.
That's right. Yeah, that's the one I'm thinking of.
Okay.
John Eastman accepted that on behalf of the Claremont Institute at the White House. And so to me, it was just, Trump and his people buttering up people like John Eastman, and, creating that cultish kind of loyalty, by providing recognition and like stature and all these things. So it's just an interesting note, because I think that was issued, did it say 2019?
Yeah.
Yeah, just
Yeah.
the year
November
before
2019.
John
Yep.
Eastman. Yeah. So a year before the election. I mean, it's just interesting. Yeah, you
It
could,
was
you don't have
really,
to
yeah,
play
I'm
it,
gonna
but you
play it.
could
No,
play
I'm gonna
it.
play it. Yeah, I'm gonna play it. It's not that long.
And as one of America's leading think tanks, the Claremont
Soundtrack.
Institute has made invaluable contributions to the history of American conservative thought. Claremont educates, reminds, and informs Americans
I'm
about the
reading
founding
this
principles that have made our country the greatest nation anywhere on earth. Through publications, seminars, and scholarships, they fight to recover the American idea. I know it well. By teaching about the Declaration of Independence,
These are
the
two
Constitution,
documents we
the
never
writings of Abraham Lincoln.
read. Here's all our white people.
The Claremont Institute helps preserve our
Hey,
national
there's a
traditions for
pompous
generations to come.
ass.
Accepting the National
There's Tommy
Humanities Medal on behalf of
Princeton.
the organization is
Yeah.
Claremont Institute President Ryan
Oh.
Williams. Thank you very much, Ryan, for being here.
Ryan, you're so horrible.
Claremont Institute.
Wait, what?
He was the
championing
president at the time the
nation's founding
79 Days Plan
principles
was
and
written.
enriching American minds.
Look at him.
Its publications
I'm
and
a
public
little
events
fast,
have
Will.
deepened
Help
our
me
understanding
over.
and appreciation of American freedom, democracy,
Ooh, that's
justice, and rule of
so
law.
ridiculous. Claremont means none of those things. Oh, look,
Look,
there's
that's John
what's
Lovett.
his name? John Lovett.
John Lovett. Or wait, what's his name?
No,
No, that's
John-
not right.
No, it's Angelina Jolie's dad. Whatever the fuck his name is. Thank you. Thank you. I hate them. I hate them. Let's see. I wanted to go to another. Wait, there was another one that you had. Oh, this is
Could
the
you
Laura
imagine being
Ingraham.
like a soldier, like wounded in combat, and you're like sharing a stage with a fucking dumbass fascist think tank?
John Voight? Yeah, a fascist
Oh
institute,
God,
and
sorry.
John Voight. That's what his name is. Yeah.
John
I mean,
Boy,
he's good
sorry.
in
Sorry,
National
John
Treasure.
Lovett. I'm so sorry.
I think John Lovett's an asshole now, though, if I'm not mistaken. Am I wrong, chat? Maybe I'm wrong. I don't know. Some of those SNL people,
I don't know.
like,
He's super
went off the right-wing
outspoken
deep end.
about Yeah, he's super supportive and outspoken about the Israel and Hamas. I think he's Jewish, right?
Oh, okay. Oh, yeah. Yeah, I think he
So
is.
he's been pretty helpful in that messaging, but I don't know anything
Oh,
else
okay.
about his politics.
Yeah, I don't. I'm probably confusing him with other people. This is another one you shared. This is December 9th, 2020. Yeah, this is from July 17th, 2022. This is Laura Ingraham. I called her a cunt and got kicked off of Twitter once. John
I still
Eastman.
can't believe she had sex with what's his name? Dinesh.
Which one? Oh, Dinesh?
Wait, was it
Oh, that's
Dinesh?
right. That's right. We went through
Yeah.
Dinesh's dating history on a previous stream.
Ew.
And so you can
Yeah.
find that. Yeah. Ew. It was. We all needed a shower, an acid shower after that. Okay. John Eastman, Texas election lawsuit. Terrific for Supreme Court. Constitutional scholar discusses Texas claiming 4 battleground states violated Constitution with election management.
Did these states conduct an election?
Oh, I hate his voice.
Breaking tonight, the Supreme Court is giving Georgia, Pennsylvania, Michigan, and Wisconsin until 3 p.m. Thursday to respond to an election lawsuit filed today by the state of Texas. The suit arguing that those states violated the Constitution in the process of appointing presidential electors by unlawfully abrogating state election laws. We're also learning tonight that Louisiana is about to join that Texas case. Joining me now is John Eastman, Claremont Institute Senior Fellow, former Supreme Court law clerk, and constitutional scholar.
Can't wear a tie.
John, for the lay people out there, tell us why this lawsuit is one that we should be especially all paying attention to, given the thing called original jurisdiction. Not to sound like geeks here, but take it away.
No, but it's
He's
great
begging
inside
for
baseball.
law
Look,
fees,
one of the
fees
things
right
that
now.
most people don't know is, the Supreme Court normally is the appellate court of last resort, but in a couple of types of cases, they have original jurisdiction. And in one of those types of cases, it's original and exclusive. And that group are cases between two states. We didn't want states warring with each other, and they gave this power to settle disputes between the states to the Supreme Court exclusively. So Texas has named Pennsylvania, Georgia, Michigan, and Wisconsin for violating election law. Now, the underlying issue there is a terrific one for Supreme Court because it doesn't turn on proof of the allegations of fraud and the Dominion machines and all these other things that are huge evidentiary matters.
That we can't prove.
It turns on a very simple legal question. Did these states conduct an election in violation of their state law? Because Article 2 of the U.S. Constitution says that the body that has the sole authority to create the manner for choosing presidential electors is the legislature of the state. And they do that by their state statutes. And when the Pennsylvania Secretary of State ignores those state statutes, sends absentee ballots out contrary to those state statutes, doesn't do voter identification or signature checking contrary to those statutes, those violations of statutes that were designed to prevent fraud are enough to trigger the federal constitutional violation that Texas has alleged.
So now the briefing schedule is what it is. It's very expedited. Does that mean the case will definitely be heard by the court, or could they still kick it out?
They could still kick it out. The way original jurisdiction works, the court has claimed to have, even on state cases, some jurisdiction discretion on whether to take it or not. So Texas had to file a motion for leave to bring this original action, and that's what the defendant states have been asked to respond to.
What's your gut?
I think they said it so quickly because.
What's your gut? Will they take it?
My guts, they're going to take it. My guts are going to take it and look at it on the merits. This is an extremely important legal issue that the Supreme Court has already twice in our history said, if election laws of the state are not followed, that violates the federal Constitution. They did that in Bush versus Gore, and they said that back in 1892 in a case called McPherson versus Blecker.
Well, John, this is fascinating. These are the cases.
Same case he cited in 2000.
That I've been waiting for.
Wow.
I can't wait to see where it goes.
What a dick. What a dick. Meadows says stays. Okay, I can't get. I don't want to get distracted on that. Okay. Let's see. Hold on. I'm gonna share. Share just a minute. Wait. Remember the teabaggers? I mean, that's the thing. That's Ginny. That's Ginny and Cleta and all those bitches. They're all teabaggers. And I don't mean in the fun, frolicky sense.
And
All
what's
right.
her name? Cheetah
Which one?
print bitch face.
Sydney.
No. Oh wait. Leopard print bitch face. Stupid hats.
Oh, the other one. No.
Amy.
Kramer?
Amy. Yeah.
Amy. Oh, sorry. Of course. How could I forget Amy and Kylie Jane? Jane. Okay. All right, we're back. So here, all of that to say, he also talked about his. They also brought up his intervention in that case that Texas tried to bring against states, saying that they ran their elections illegally and all that nonsense. Which basically, if you remember, I believe the Supreme Court said you don't have any standing. Get the fuck out of here. So, fun fact, Eastman, they didn't. Let's see. Repeated reliance on Jesse Morgan. Oh, this is a good one too. Another example of a respondent's conscious disregard of the evidence is his repeated reliance on the affidavit of Jesse Morgan, who claimed he trucked in ballots from New York as the basis for his contention that fraud affected the election outcome in Pennsylvania. At trial, respondent repeatedly claimed that Morgan stated in his affidavit that he transported approximately 200,000 ballots, but Morgan did not say that. He stated that he, quote, sucked at estimating numbers and therefore could not say if he transported 250 or 7,500. So this is, I mean, I can only say that this is a panic by Eastman. But I'm telling you, if this stuff doesn't come up in the fucking Georgia trial and in Jack Smith's, I'm going to be real mad.
Well, hold on before you go on. But there
Yes.
is there's December 9th, so we just watched that video. That's good.
Oh, okay.
But
Perfect.
let me show you one thing real quick. Hold on.
Okay.
Now, see, you brought this up, so
Oh boy.
hold on. I gotta show you something here.
Okay.
I'm
My
pulling it
attorney
up
got
now.
arrested. Leopard print bitch face. Yeah, it makes sense. And we knew who it was. That's the funny thing, is that eventually
Yeah, I appreciate you guys knowing me well enough
only
to
it only
figure
took
that
a
one out. That
second.
was
Okay. Is it the one you just dropped in? No, that's one from
No.
half an hour ago.
I'm looking for it. I'm gonna find it
Okay.
here. You can keep going and then I'll put it in
Okay.
there. That's okay.
All right, cool. So December 9th, whoops. If you were just with us, we just watched a little bit of a video on December 9th when Mr. Eastman decided he would appear on Laura Ingraham's bitch show. On December 9th, the respondent, meaning John Eastman, filed a motion to intervene and bill of complaint in intervention on Trump's behalf. So notice all along he's been in Trump's employ, if you will. The bill of complaint and intervention adopted by reference and joined in Texas's bill of complaint, thereby incorporating multiple allegations respondent knew or consciously avoided knowing were false, including the probability of former Vice President Biden winning the popular vote in the 4 defendant states, given President Trump's early lead in those states as of 3 a.m. on November 4th, 2020, is less than 1 in a quadrillion, or less than 1 in a quadrillion to the 4th power, giving rise to substantial reason to doubt the voting results in the defendant states. Those are quotes. Election officials in Philadelphia and Allegheny counties illegally adopted differential standards designed to advantage Biden. The Pennsylvania Department of State violated a Supreme Court order regarding the segregation of mail-in ballots received after Election Day by changing guidance issued by the Secretary of the Commonwealth before the ink was dry on the court's 4-4 decision. 58,221 mail-in ballots in Pennsylvania were returned on or before they were even mailed to voters, thus implying some kind of fraud occurred. The Georgia Secretary of State's changes to the signature verification process resulted in a lower rejection rate for mail-in ballots. And there was rampant lawlessness arising out of defendant states' unconstitutional acts affecting an outcome determinative number of votes. Well, guess what? Fun fact, these allegations were false, and respondent failed to do anything to evaluate the evidence on which they purported to be based. Yes, it's true. He said it over and over again. No, I didn't verify those numbers. No, I didn't know where they came from. With respect to the statistical allegation regarding the odds of Biden winning, respondent admitted it was inconsistent with the declaration of Charles Cicchetti, upon which it was purported to be based, but that he had not time to look at it carefully, stating, quote, I don't think I had the opportunity to kind of do a deep dive or on whether it was completely accurate summarization of the Cicchetti Declaration or not, and that it had, quote, appeared reliable to him. Yet he carefully read the declaration or asked an expert to do so, which he did not. The misrepresentation would have been obvious. Indeed, as Professor Grimmer, who was a fabulous and, might I say, quite handsome expert for the state, yes, he did, explained the probabilities that Cicchetti calculated were based on, quote, ridiculous assumptions. Assumption that Biden would receive the same number of votes in 2020. Stay with me, kids. He used the assumption that Biden would receive the same number of votes in 2020 that Hillary Clinton received in 2016. Yeah. Assumption that Biden's share from early arriving absentee ballots would be equal to share from late arriving ballots. Failed to account for well-known phenomenon called blue shift. When confronted with his misrepresentations about the probabilities of Biden having won the election, Eastman was dismissive, claiming it was only a, quote, preliminary part of the introduction of the brief, not the meat of the allegations of the brief, and therefore, in his view, it was not material to the substance of the brief and not high on the priority list. Such claims further demonstrate his disregard for the truth or for any facts that would undermine the position he continues without basis to advocate. Boop, boop. Let's see. A respondent could not identify reliable evidence to support his claim after initially deflecting. Well, again, this was Texas's brief, not mine. I remember when he said that. Respondent cited two bases from which he claimed he could make a good inference that there was an intent to benefit the Democrat side of the ticket. Okay. How'd you leap there, Johnny? First, he claimed that Secretary Bakvar's September 2020 guidance concerning the procedure that county boards were to follow upon receipt of an absentee or mail-in ballot violated the state election code. But, as respondent knew at the time of his December 9th filing, the Pennsylvania Supreme Court had already concluded that on October 16, 2020, that the guidance accurately summarized the law. Neither respondent's filing nor the Texas Bill of Complaint disclosed the Pennsylvania Supreme Court's earlier ruling. So just don't. It's like put your earmuffs on and go bop bop. Cicchetti himself criticized the bill of complaint. I just want to read the footnote, confirming that the declaration did not support what the Texas AG Paxson claimed was used without his knowledge. Oh, so Cicchetti says, I don't even know there. I don't even go to that school. And further, that he found no evidence of fraud in the analysis he performed. Okay. Respondent was well aware of the blue shift phenomenon before the election. Oh, that's right. He did talk about that. Respondent at the Claremont Institute 79-day report, which I also have a copy of pulled up, stating the winner will not be known on election night due to millions of uncounted mail-in ballots in 5 battleground states. The post-election period will likely see a Trump lead steadily eroded by mail-in ballot counting. This from the actual GOP, basically Claremont 79-day report. Okay, so he already admitted that he knows how this works. Yeah. Okay. Anyway. Let's just see. With respect to, second, he referred to allegations that Philadelphia and Allegheny counties adopted standards favoring Biden. Although the original complaint references a November 18th campaign lawsuit against Secretary Buckvar, claiming those, I don't know if I'm saying that right, I apologize, violated Pennsylvania law. It omits any mention of the November 21 and 27th District Court and Third Circuit decisions dismissing the action and denying the campaign's motion for an injunction pending appeal. I am sorry when I do that little pointy thing. With respect to the allegation that Pennsylvania violated a Supreme Court order concerning segregation of certain mail-in ballots, the evidence is clear this claim was false. Alito issued an order requiring all counties to comply with the guidance provided by the Secretary of the Commonwealth to segregate ballots by mail after 8 p.m. on November 3rd, and that all such ballots, if counted, be counted separately. The Secretary of the Commonwealth never changed that guidance. God, it's just like outright lying. It's just outright lying. It's crazy to me. All right, I need one break because I need to pee. I'm going to hold on. I'll put some music on. Hold on. It's really just a quick pee. So sorry. Okay. I'm back. I'm refreshed. I'm ready. All right, let me check in with chat because I'm just ignoring you and I hate it. Let's see. The Red Mirage. Oh, yeah. Oh. MAGA attorneys gamble accreditation. That's actually very good. I like that very much. Leopard print. Dancing in the streets. Americans won't tolerate some MAGA dictatorship. I agree. This is the thing. I don't. I'm not really. I'm not worried about him winning or anything like that. I'm just in the mood for some justice. And even I, the cheerleader for Merrick Garland, am beginning to say, hey, come on now. Come on now. Anyway. All right. Back to the business at hand. Here we go. Oh, this whole thing with mail. So there was I won't go into the detail, but the bottom line is that when he claims about mailing and received before they were even mailed, there's this weirdness with the database about what mail date actually means and the change over time and what that field has meant and all of this kind of stuff. The bottom line was they walked through why that is not true, and how you can debunk that. So basically, again, the important takeaway here is that a lot of the key arguments that we continue to hear MAGA spout are debunked through this hearing, which is very helpful. Very helpful. Actually, you know what I'd love to do? I would love to go and make like a two-sided document that has like claim, debunk, claim, debunk, claim, debunk, claim, debunk, as a way to have conversations with folks that have certain talking points. I think we need that because I get confused sometimes. Anyway. With respect to the allegation that changes to Georgia's signature verification, this was a good one too. Oh my God. The claim was based on calculations about the overall rejection rate, not on the signature match rejection rate. The bottom line is all of this stuff about signature verification, they got it wrong. Eastman got it wrong. So this big fucking constitutional fucking expert just was wrong. And he knew it. And he ignored it. So, finally, respondent had no compelling evidence that lawlessness affected the outcome determinative number of votes in any of the states. Blar. Womp. The Supreme Court denied Texas's motion for leave to file a bill of complaint. Haha, don't have standing, bitches. And then this memo, right? This is the memo. By mid-December, it was clear to Trump and his allies that their options for attempting to alter the outcome of the election were vanishing. Courts and legislatures were consistently rejecting their efforts to decertify Biden electors and certify Trump electors, and the Electoral College had met and recorded their votes. In addition, following the vote, it became clear that the January 6th count, neither House of Congress would vote to reject any slate from a state won by Biden, ensuring that if the procedures of the ACA were followed, Biden would be certified as the winner of the election. Respondent thus spearheaded a new strategy to have Vice President Pence use his role as President of the Senate to prevent Biden's victory. Laid out in two memos he provided to Trump attorney Boris Epstein. I want to hear your name more often. Yeah, come on. Let's get him in. Let's drag him. I want to see a mugshot. I want to see Boris's mugshot. On December 23rd, 2020 and January 3rd, 2021, the strategy called for Pence to refuse to count Biden slates from 7 states. Arizona, Georgia, McGashan, Nevada, New Mexico, Pennsylvania, and Wisconsin. That was pretty good, actually. If I do say so myself. Arizona. Let me give them their due. All right. Under various scenarios, Pence would unilaterally refuse to count electors from those states on January 6th and either declare Trump the winner unilaterally adjourn the joint session and allow state legislatures to engage in a comprehensive audit or investigation of the election returns in their states, with 10 days to go. and possibly certify pro-Trump slates of electors that would allow Trump to win. See stipulation to undisputed facts. Oh, we will. Respondent knew this strategy violated the ECA, but falsely claimed that there was very solid legal authority and historical precedent for the view that the president of the Senate is responsible for the resolution of disputed electoral votes. Oh boy, did they go over that too. And all the members can do is watch. He also knew that the proposal that Pence adjourned the count violated the ECA's requirement that counting be completed on January 6th. But asserted that this requirement was also contrary to the vice president's authority. So they really went in on. Yeah, I don't think he's married to Natasha. All Washington voting is by mail. I mean, it's just come on. More people have to vote. That's what happens. I even want Republicans to vote. How about that? How about that? But yeah, no, yeah, he really it's just okay. Yeah, the bad knobs. That's right. Okay, let me go back to this. I'm so sorry. Okay. To justify, respondent falsely claimed in his memos that illegality and fraud had demonstrably occurred. See, this is the thing. And yet, when asked on the stand about any of that illegality and fraud, he could not claim it because he was under oath. So, yeah. In the 2020 election, as part of a strategic Democrat plan to systematically flout existing election laws for partisan advantage. That was his quote, while omitting any mention of the myriad courts that had already rejected these claims on the merits and otherwise, like 64 to be exact. Instead, he argued it was necessary to take bold action and to jettison Queensberry rules. Respondent emphasized as critically important to this radical plan that, quote, VP Pence should exercise his 12th Amendment authority without asking for permission, either from a vote of the joint session or from the court, end quote. Instead, he should act unilaterally and then claim his actions were unreviewable as non-justiciable political questions. I'm going to have to practice that. It is worth pausing to consider what respondent's memoranda proposed, that Pence himself on the ticket should unilaterally declare that the ECA to be unconstitutional and throw out or refuse to count the Electoral College slates properly certified by the 7 states without regard to federalism or any notion of checks and balances. In an effort to avoid discipline, respondent now asserts that his memos, which are replete with false and misleading representations and omit key legal considerations and critical material facts, were not advancing any particular strategy, and that he was just laying out, quote, scenarios or thoughts that people had expressed for internal discussion, and that these memos did not take a position, and that he did not know whether Trump would even review them. I mean, I didn't know. How was I supposed to know? Justiciable. Okay. Respondent's efforts to recharacterize the memos at trial are not credible. Respondent drafted and sent the memos to Trump legal advisor Boris Epshteyn in his capacity as counsel to Trump and his campaign. Respondent had regular interactions with Trump over the course of the month of December and early January. The memos do lay out a clear plan and recommendation for, quote, bold action that should, quotes, in quotes, be taken on January 6th. And respondent, together with Trump and others, advanced the plan laid out in the memos in their communications with state legislators, in their communications with Jacob and Pence, and in their communications to the public, including on January 6th. January 6th memo. VP Pence should exercise his 12th Amendment authority without asking for permission. Oh my God. Respondents' efforts to downplay the import of the memos also fail to account for the fact that, as Trump's counsel, respondent had a duty to provide his client with complete and candid advice. See California Rule of Professional Conduct 2.2, bitches. And as respondent conceded, the memos are the only record he produced of his claimed research into the vice president's authority. Right. So he knew his claims of fraud lacked credible support. Respondent knew that his claim in the January 3rd memo that outright fraud, in his quotes, had, quote, demonstrably occurred and affected the outcome of the election was false when he made it. Let me see if I can go into some of this one. In emails on November 28th and January 2nd, respondent bemoaned the lack of, quote, hard documented evidence of the fraud, complaining, quote, serious forensic investigations have been blocked at almost every turn, except for Coffee County. When pushed on the issue at trial, respondent became evasive and sought to expand, quote, fraud to encompass alleged illegal conduct by non-legislative actors that he claimed, quote, opened the door for fraud. Ultimately, however, respondent and his witnesses conceded that it would be nearly impossible to establish whether any fraud occurred. Quote, proving the extent of fraud after the fact is a very difficult and, in fact, near impossible thing. That's from respondent's own stuff. Respondent further admitted that he did not know the extent to which fraud affected the outcome of the election in Arizona, Michigan, Nevada, New Mexico, or Wisconsin. So there you go. He ignored reliable evidence that the election was not tainted by fraud and court decisions rejecting claims of fraud. Evidence at trial showed respondent was aware prior to January 3rd of extensive evidence from reliable sources that the election had not been tainted by outcome determinative fraud and that responsible government institutions had repeatedly rejected such claims, but that he consistently dismissed and ignored it. For example, he dismissed pre-January 3rd statements and reports from election officials rebutting election-related disinformation and confirming the election results, stating that he didn't give them much credence. Oh, grimmer. Explaining that there is no evidence in respondents' exhibits or in his answer that demonstrates outcome determinative vote fraud. His distrust of partisan. Respondent also admitted he did not. Oh, this was a good one. Okay, thank you. As he was going through the data that was being given to him, respondent also admitted that he did not contact election officials from either party to request election-related information. He admitted it on the stand. He dismissed CISA November 12th statement that there's no evidence that the voting system deleted or lost votes, etc. He ignored the November 16th, 2020 statement by 59 of the country's top computer scientists and election security experts, including two he cited for support, Alex Halderman and Harry Hursty, stating no credible evidence had been put forth that supports a conclusion that the 2020 election outcome in any state has been altered through technical compromise. That's a quote from that, and that such theories were unsubstantiated or are technically incoherent. Yikes. He dismissed Attorney General Barr's December 1st, 2020 statement that, quote, we have not seen fraud on a scale that could have affected a different outcome in the election, end quote, claiming, quote, that there was not a significant enough investigation. In stark contrast, remember that you was testifying on behalf of John Eastman, testified that Barr's statement, quote, settled the matter for him. Yep. He dismissed the hand recount. Which disposed of any doubt whether ballots scanned multiple times were actually counted multiple times. And he's continued to imply that fraud occurred at the State Farm Arena, even though he admitted at trial he, quote, had no evidence one way or the other whether any fraudulent ballots were processed there. He ignored the January 3rd court orders, concluding that fraud allegations raised by plaintiffs in the 7 states lacked merit. Let's see, Law v. Whitner. There is no credible or reliable evidence that the 2020 general election in Nevada was affected by fraud. Let's see. Here we go. Let me go back to the footnote. Respondent repeatedly claimed that at trial that Halderman issued a report stating, quote, that votes were flipped from Trump to Biden, end quote, in Antrim County, Michigan. In fact, Halderman concluded, quote, Antrim County's final results matched the poll tapes printed by the individual ballot scanners, and there is no evidence that the poll tapes are inaccurate, except for in specific precincts where particular circumstances I explain affected a small number of votes, mainly in down ballot races, end quote. This is why this is so important. I know it's a little, I'm sorry, I'm kind of jumping around, but it's just, and Gal, anytime, just like jump in. I just keep reading. All right, so that's Nevada, la la la, and Wisconsin, blah blah blah. Respondent has tried to support his fraud claims with sources he knew or consciously disregarded were inexpert, unvetted, and unreliable. At trial, oh, I love this. At trial, respondent called 3 of the individuals whose 2020 election analyses he claimed to have seen and relied upon before January 6th. The judge was very careful to keep all of the testimony within specific time frames so that it was really that they were able to really prove that everything happened prior to certain other events. It was pretty well done. I mean, it was really well done. I shouldn't say pretty. Okay. John Droz, Roy Blahar, and Stanley Young. All of them conceded they could not demonstrate that fraud occurred in the 2020 election, a point which their reports expressly emphasized, and of which respondent was well aware. Moreover, none had the expertise necessary to credibly evaluate claims of fraud or anomalies in the 2020 election, a fact which respondent could have easily determined by consulting with bona fide experts like Grimmer prior to January 6, but which respondent consciously avoided doing. Ooh, let's see if there's anything good in here. Question. Were you aware of this court finding prior to January 3rd? Answer. I was aware from speaking with a counsel in the case that had lost on their challenge in district court and had been denied review on appeal. Question. Do the court's concerns about declarant Jesse Camsol's methodology cause you to reevaluate your opinion of its reliability? Answer. It caused me to go back and look at his declaration, and I find the court's analysis here to be lacking. Oh, interesting. Is that respondent? Is that? I guess that's him. Burp, burp, burp. Do you recall the Ward v. Jackson case? Answer. I vaguely recall the case. I don't know the specifics. I was not involved in any of the Arizona litigation. I do remember. So this is Eastman. Were you following the Arizona litigation in late December or early January of 2021? Answer. I think, quote, following, suggesting a more closer attention to it than I had time to be giving it to the time. I was aware that there were litigations being filed, but I did not at the time have a chance or the time to review the specifics of those litigations. Oh my God. So terrible. Terrible. Acknowledging, recommending. Okay, so that's that. Statistical contrast. Oh yeah. They did statistical contrasts and things like that. His witnesses came with their worst PowerPoints and their worst reports, and that's it was pretty sad. Basically, none of them could stand behind any of the comments that they had made in support of Eastman. Moreover, none had the expertise to credibly evaluate claims. Okay, let's assembled by draws from subscribers. This is great. John Draws. Everybody got their PhD in the 1970s. If they did get a PhD, I'm still doubtful. So here's one of them. Assembled by draws from subscribers to his biweekly newsletter, which was frequently skeptical of climate change. The group, now he says this is his group of experts. That's what John draws. The group lacked a single member with election-related experience or expertise. It was all his crusty grannies. Droz testified that he did not seek out people with election-related expertise because he believes numbers are numbers. He couldn't tell you what his PhD was in because it was in statistics, and that's all he said. Not data science, not any of that, just statistics. The problem with this tactic of avoiding qualified election experts was, as Grimmer explained, that one cannot understand the significance of a statistical observation about an election without a detailed understanding of, quote, what goes on in elections. That is, without an understanding of what is normal, and there's no basis for declaring an observation anomalous, which is their favorite word. So don't drink to that word because it comes up a lot. Indeed, Blahar, Droz, and Young each admitted on the stand under oath they made no attempt to determine if the alleged anomalies they identified were any more present in the 2020 election than in any other election in U.S. history, primarily because they didn't look at any other elections in U.S. history for the most part. Respondent, November 28th, Eastman says, it would be nice to have actually hard evidence. Oh, wait, we read that. Only Dr. Young of the three was qualified at trial as an expert, but only in statistics, not with respect to elections. Droz has degrees in math and physics and spent most of his career at GE doing quality control and testing before he retired in 1980. Blahar has an undergraduate degree in geography from
The
Indiana
young
University.
buck. Young buck.
He's the young buck. An MBA
That's
from
right.
Penn State. In the party's June 5th, respondent falsely claimed Droz and Blahar were both statisticians. Respondent likewise failed to ask if they had erection-related experience. They didn't. Oh my God. As a result, the analyses were bullshit. I mean, really, they were. Yeah, it was just basically they stepped through each of the work of those quote unquote, well, those witnesses and debunked. I mean, it's exhaustive, so I recommend if you're a nerd about that, I would definitely read it. But I think we need to it'd be nice to have like a cheat sheet. Let's see. Let me just see if there's anything like crazy jumping out here. Because this is all statistical stuff and the vote spike. Testimony from two witnesses who conducted post-January 6 analyses of the election that respondent cited as post hoc support for his fraud allegations. Michael Gableman, who cries like a baby. All right. Justice Michael Gableman. And Garland Favorito. He loves Gal. Oh boy. Similarly, he loves you. Similarly, failed to support respondents' fraud claims. A former Wisconsin Supreme Court justice with no prior experience with election law or administration, but man, can he cry on demand. Gableman headed a $650,000 effort to investigate the 2020 election. I've got some good footage of Gableman. At trial, Gableman admitted that he, quote, does not have the numbers to quantify the effect of the issues he purported to identify in the Wisconsin election, a fact of which respondent was aware. I don't think Justice Gableman made a determination of how many ballots were fraudulently cast. Yeah, isn't that convenient? His final March 22 report repeatedly noted that his investigation failed to determine whether various election irregularities occurred or to quantify their effects. Let's see. A report draws no conclusions about specific unauthorized outside interference or insider threats to machine voting. No statistician was engaged to quantify the number of allegedly improperly cast ballots in residential care facilities. Group has not been able to run ground all issues relating to obtaining cell phone data in connection with Dropbox analysis. Aspects of voting machine analysis not yet complete. Gableman admitted he was fired from his position. A Wisconsin court found that his group accomplished nothing, gathered no measurable data, organized no existing data into any analytical format, and generated no reports based on any special expertise. Yeah, that was a good one too. Like Gableman, Favorito admitted that he could not quantify the number of ballots affected by many of the issues about which he raised concerns. Yeah, that's right. And his name is Garland Favorito. And he says it just like that because he's from Georgia. Favorito also relied on, remember Mr. Geels, the toilet paper that was handed to Eastman before he testified in front of the Georgia State Legislature. Remember that one? Well, Favorito also relied extensively on Geel's flawed analyses and therefore inherited all its deficiencies. So Favorito based shit on shit. And there you go. As to Favorito's claim that 873 deceased voters voted in Georgia, Grimmer noted that Georgia's canceled voter files indicated that 863 of those individuals died after Election Day. Okay? And that the records indicated that all but 7 of those individuals voted in person, meaning that they would have been required to present photo identification. All the few who voted absentee would have needed to return their ballots well in advance of being removed from the voter file. Grimmer also found numerous errors and flaws in Favorito's testimony and report, including his apparent misunderstanding of how data matching and data merging work, links in the report that did not connect to the correct information, a failure to explain the methodology underlying certain numerical conclusions, and the reporting of numbers that Grimmer could not replicate. Could not. Sorry, I'll come back. Wow. I just love that. I'm so happy. I'm so happy we have this. I'm so happy. All right, let me see where we're going with this, because I want to see. Okay, so don't forget, we're on page 31 actually. I know it says 21, but it's really 31. Respondent knew his claims regarding illegal conduct lacked credible support and had been rejected by courts. So that's the other piece they're pushing, right? Is that all these states made illegal changes to their voting rules and blah, blah, blah. Well, it doesn't matter. All of that stuff has been litigated. It doesn't matter. So that's a big womp womp. Oh, wait, let's see if there's anything juicy in here. Question. The court also reached a finding regarding whether unlawful votes were accepted during signature verification specifically. Do you recall that? That sounds right. I don't recall it specifically, but it sounds likely. So your position on the 6-page memo is that anyone who registered to vote after October 5th should not have their vote counted, correct? Answer. That's correct. Question. But Arizona election officials were doing what the Ninth Circuit had told them to do, correct? Answer. Yes. When the Ninth Circuit, when the Ninth Circuit acknowledged that the change in registration deadline violated the state law, it's my view that that should have been the end of that matter, and Judge Bybee, in dissent, agreed with my view on that. Okay. Let's see. Plaintiffs are unable to show a likelihood of success on the merits. So, Dr. Eastman, you don't recall having read this decision prior to January 3rd, 2021? Answer. I don't recall, but had I read it, this is a decision on a motion for preliminary injunction, which is not a ruling on the merits. Question. And the Michigan Court of Appeals denied leave for appeal on this case. Did you know that? Answer. I have a vague recollection of that, yes. But again, a denial of review of a denial of a motion for a preliminary injunction is not an ultimate ruling on the merits in a case. Oh my God. Question. The court noted Mr. Sito's affidavit, which was one of the supporting affidavits, which was, quote, rife with speculation and guesswork about sinister motives. And then the last sentence of that paragraph is, quote, there is no evidentiary basis to attribute any evil activity by virtue of the city using a rental truck with out-of-state license plates, quote. Do you see that? Answer. Yes, I see that. Yes. Question. Do you recall knowing about the court's rulings on that prior to January 3rd of 2021? Answer. I don't recall at the time. I do recall having been familiar with the dissenting opinions in the Supreme Court questioning the legality of what the district judge did here, which is to make an evidentiary determination without a hearing based on competing affidavits on a motion to dismiss, which is highly irregular. I do recall that. Well, so then you did. Question. All right. And so were you familiar with the Trump v. Biden case when you wrote the 6-page memo on January 3rd? Answer. Yes, I was. Question. All right. And so you knew that the campaign had sought a recount and then challenged the results of that recount to the Wisconsin Circuit Court? Answer. I don't recall the particulars. Wait. I knew that they had done both. Question. Do you recall that the Circuit Court rejected that challenge and affirmed the results of the recount? Answer. I don't recall that. Doesn't surprise me, but I just don't recall. Question. And the Wisconsin Supreme Court granted review and then rejected the campaign's claims on December 14th. Do you recall that? Answer. Well, that's not quite what this says here. And what I'm remembering is that it rejected the broad-based claim on the indefinitely confined, because they had sought to disqualify all indefinitely confined ballots, but that it rejected the other 3 claims on laches grounds, which means that it claimed it didn't have jurisdiction and didn't reach the merits. Dork. Respondent's willingness to cast aside all these judicial decisions is striking, given his status as an officer of the court, the central role the courts play in resolving election disputes, and the time and energy.
Clip that one.
Yes.
I'm just saying. Look, it's Oompies. Look.
Yeah.
Good job, Ooms.
Yeah. It's crazy. Crazy. All right. Allowing late filed legal challenges, blah, blah, blah. Respondent knew that his claim that there were dual slates of electors was false and misleading. and provided no basis to reject electors or delay the count. Central to the strategy was the false pretext that the existing dual slates from the 7 states justified Pence unilaterally rejecting the Biden slates or delaying the count. December 23rd, Eastman email stating, quote, "The fact we have multiple slates of electors demonstrates the uncertainty of either. That should be enough," end quote. Well, it turns out, folks, it wasn't. In fact, respondent facilitated the creation of these false elector slates. Oops! When he was working on the Texas v. Pennsylvania, respondent and other Trump allies were pushing for Trump electors in the 7 states to sign and transmit slates to Congress, falsely certifying they were the duly elected. Let's see. Where's the? I want to see. He also sent. Wait, in mid-December, respondent participated with Trump in a phone call to RNC chair Ronna McDaniel, asking for Ronna's help gathering contingent electors, and that's in quotes. And he also sent
Yeah, and
multiple
she is
emails.
a witness for
Oh,
Jack,
she is.
right? I'm
I
pretty
I
sure
think she
that
is.
was
Oh,
like
I
in the
think she
last
is.
month or so. Yeah.
Yeah, there was that list of witnesses, I thought. Or at least some. Let's see. And he also sent multiple
Sorry, I
emails
threw
to
you off.
no, please do. No,
Oh
you don't
shit,
throw
I
me
did it
off.
again.
Do it
Oh my God.
again. Do it again. Do it multiple times. You're brilliant and I love you. You're just following, like the lead set by the host. And he also sent multiple emails to campaign officials, emphasizing the urgency and importance of transmitting slates of Trump electors. Come on. Respondent knew then that the slates of Trump electors submitted on December 14th were not certified by any official or legislative body and had no authority, and that they were not the duly elected blah, blah, blahs. On December 19th, respondent wrote an email confirming this. Quote, "Not one legislature has acted unless those electors get a certification from their state legislators. They will be dead on arrival in Congress," end quote. I forgot about that one. Thus, as
I found
respondent
your
knew.
place when you come visit me. There's a place called Spaced Out Smoke. It's vapes, glass, cigars, and more.
Really?
Like, I
Cannot
think
wait.
I don't know if they have. I don't know
Cannot
if they
wait.
have the weed stuff there. I'll have to check for you. But
I'll figure
there's
it
a bunch
out.
of those shops. I think there's more of those shops than there are grocery
There
stores
are.
here. So
Oh, wow. I can't wait. It's gonna be a road trip. I'm doing a road trip. Let's see. As acted, So, dead on arrival. Respondent knew, and you confirmed, remember, his witness, fabricated dual slates did not generate a real dispute for Pence or anyone to resolve on January 6th. He's a liar. There's a little more on you. To the extent respondent contends that dispute arose from litigation, the contention is also false. He knew that claims of fraud and illegality were roundly failing in the courts, knew that his claim that the ECA was unconstitutional would fail, and did not believe that the Supreme Court would intervene. Oh my God, the receipts. It's like a CVS up in here. Respondent knew his and Trump's strategy was illegal. Under the ECA and Constitution, what should have followed from election day, and indeed what did follow, was straightforward. The executive of each state provided a certificate of ascertainment to the archivist of the United States, December 14th. And in fact, the fake ones were sent to the archivist too. On December 14th, 2020, the certified electors.
I told you.
You did. The 12th Amendment does not specify who counts or how to address. And that was the other thing. It was like the argument that the vice president, as the president of the Senate, has the authority to resolve disputes. That's come up a lot, that phrase. And there's been a lot of conversation about this is not the type of dispute that they meant. So anyway, that's the short version. There's a much smarter version inside here. Let's see. So at trial, you testified unequivocally that Pence had no authority to reject electoral votes for Biden on January 6th. He can only accept them as legitimate, and thus no dispute over the electoral votes justified Vice President Pence's intervention. This again, one more time, is Eastman's witness. It is his witness. Had long acknowledged the vice president lacked dispute resolution authority. Respondent is a graduate of the University of Chicago's Law School, Supreme Court clerk, constitutional law professor. Should have known. Writing in an email. The 12th Amendment only says, this is from an email of Eastman's, the 12th Amendment only says that the President and the Senate opens the ballots in the joint session and then in passive voice that the votes shall be counted. U.S. Code 3, Section 12, merely set, or Constitution, sorry, I'm terrible. Article 3, Section 12, I'm an idiot, says merely that he is the presiding officer and then spells out specific procedures, presumptions, and default rules for which slates will be counted. Nowhere does it suggest that the President of the Senate gets to make determination on his own. So there you go. 15 doesn't either? Oh, 15 doesn't either.
Look at that footnote. Look, that was from an email on December 31st, Trump v. Kemp, stating, I have no doubt that an aggressive DA or U.S. attorney someplace would go after both the president and his lawyers once all the dust settles on this. And then January 11, 2021, respondent emailed to Giuliani asking to be placed on a pardon list.
Wow. Yikes. What a difference a couple weeks makes.
Oh, let's screenshot that. Go back up. 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 Got it. Thank you.
Got it. You're welcome. Thank you. Yeah, and basically they document how he held this view. He's argued this. We just heard him argue some stuff, and he was telling the legislatures they had the come on. All right. Original view was consistent with longstanding practice. Blah blah blah. Yeah.
Boing, 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 boing,
boing, boing, boing.
Boing,
Question.
boing, boing.
Question. So the difference between the final versions was that in the Senate version, the vote of one house would be sufficient to make the decision, whereas in the House version, both houses of Congress needed to be in agreement to overcome the state choice. Is that accurate? John Hughes answer. Remember, witness for the defendant. Yes. So there you go. No man is allowed to be a judge in his own case. That's right.
That would be a good country song.
It would. I'm going to do a Federalist song. That's what I'm going to do. Let's see. No man is allowed to be. Okay, wait. But then what is this? I want to go to the part where he said.
Hold on, I can read it really. Let's see how fast I can.
The part where
the pen should act without asking permission. Woo! Whoop a woo! That's a bad one.
Reaction was he instructed Joseph, who's Joseph, to hold off because a loss would completely tank the January 6th strategy. Oh, wait, December 22nd, 2020. I didn't hear about this. Attorney Larry, I didn't read it. Consulted about a respondent about filing a lawsuit in D.C. federal court to test the theory of vice presidential power. Respondent advanced in his memos. Respondent's reaction was swift and unequivocal. He instructed Joseph to hold off because a loss would completely tank the January 6th strategy. What?
Oh my gosh, I remember that. That's right. They were going to. I remember this. So they were going to challenge Pence's authority under the Constitution to reject electors that they claimed had been, come to by fraudulent means or whatever. And because if that district court had ruled that Pence has no authority, legal authority, and that his position was merely ceremonial, then they would not have been able to send everybody to January 6th to try and, pressure Mike Pence to do so.
Yeah,
so they didn't want
bad PR.
A ruling. Yeah, because they couldn't, they couldn't say at that point because they would have had a ruling in the courts. They wanted to
do it. Right.
Yeah, they wanted the courts to rule after the fact, creating a constitutional crisis.
Jesus Christ. I'm telling you, people, they think because they talk in right-wing echo chambers that what they do is widely accepted, and it's not. And this is a beautiful illustration of that.
It says, let's see. Oh, okay. Where are you at?
What's the Boris Epstein thing? Respondent's reaction. He told him to hold off. Okay. December 23rd.
Oh, I see.
I'm right on line 12. Respondent wrote to Trump lawyer Boris, warning that hearings on the constitutionality of the ECA could invite unwanted counterviews and that it would be better for Pence just to act boldly and be challenged.
See, that's it. Yeah.
I mean, hello.
Yeah.
I did.
When he filed
You,
the lawsuit in Texas,
you
respondent
guys
emailed
know
colleague.
why I'm so excited
Yeah.
about this? Keep going. Yeah, keep reading. I'm sorry.
Let's see. Respondent emailed colleague to express disapproval. He wrote, "Crazy." So what do they realistically think will be the outcome of this? A federal court denying that Pence has the authority we believe he has? And how will that help bolster our arguments to Pence? It digs a hole deeper. Unbelievable.
Say it ain't
That's
so.
how I imagine that's how it went.
Be bold, Mike. Be bold. Respondents concerned that litigating the issue would undermine, okay, blah, 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 Wisconsin voters. A second case challenging the constitutionality filed on December 2nd and swiftly floundered, I imagine. In a January 4th, 2020 order denying relief, the court explained the suit rests on a fundamental and obvious misreading of the Constitution. It would be risible. Is it risible or risible? If were its target not so grave, the undermining of a democratic election for president of the United States. Wow. Plaintiff's theory lies somewhere between a willful misreading of the Constitution and fantasy. Oh no, you forgot. A willful misreading and a crime. Oh, this is the John, you wrote the American Mind article. I forgot about that. Sorry. Yeah. Eastman relied on this American Mind article. And Robert Delahunty, another amazing guy, triggered his about face on the vice president's authority. Though Yu had been his friend and colleague for close to 30 years, Eastman did not even try to discuss the article or the legal or historical support underlying the brief opinion piece with him. At trial, respondent dismissed the idea, claiming he, quote, didn't see any need for a discussion. Yu, however, volunteered that it seemed weird, quote, given their relationship. Oh my God. This is crazy. Respondent's decision not to consult was consistent with his broader approach to the January 6th strategy, which was not to provide competent and candid advice about such a momentous issue, but instead to act as a validator for a lawless theory. Oh, God. You know what he is? He's he's like Uriah Heep in David Copperfield. Yes, sir, you can do it, sir. Don't worry, sir. It'll be okay, sir. Respondents claim that blah, 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 is implausible. He never researched anything. As you disclosed at trial, he knew that respondent was working for Trump in late 2020 and, quote, didn't want to really help in any way people who asserted that the election was fraudulent or had been stolen. So, Mr. Yu, was it a surprise to you when you received the subpoena to witness, to testify on his behalf? Was that? Would you describe it as awkward, Dr. Yu? Respondent knew that contrary to the statement in his January 3rd memo, there was not, quote, very solid legal authority and historical precedent for Pence to reject. Now, here's the thing. The part of this that is interesting to me is that he takes the position under oath that he did not tell Pence to outright reject or delay even, or no, he did say delay. Let me make sure I got that right.
Pause. It was a pause.
It was a
It
pause.
wasn't a delay. It was a pause. It was
It was
just
a
gonna
pause.
pause it. We're
Just
gonna hit pause.
Put a pin in it. Put a pin in it. Nor could
Just
he.
hold on for a minute.
Just everybody cool your jets. Take a seat. Take a beat. It was and is an illegal proposal, which he knew offered no path to a legal change in the result and was designed only to delay recognition of Biden's victory and extend the window for further mischief. Enter Mike Flynn.
Further mischief.
Courtesy of Mike Flynn and folks. In a way, respondent would hope to avoid judicial review. The 12th Amendment's text does not give the president of the Senate control over the timing of the proceedings. There's a lot of argument about this and about his powers. But there was really one kind of juicy claim where he's like, I didn't say that. And everybody else was like, yeah, you did. And we're saying it under oath too, bitch. So it's just a pause. Reject. Okay. Respondents reject theory called on Pence to refuse to count electoral votes of electors who had been certified by the relevant state executive under state law after recounts and extensive litigation had confirmed the results, when no court, no legislature, or any other state entity had certified a competing slate of electors, and without the consent of Congress. Blah, blah, blah. Just this theory posited that not just that the vice president has some power to adjudicate disputes, a position itself contrary to the ECA, but that under the circumstances Pence faced on January 6, he had the unilateral power, absent any dispute, to refuse to count 7 states' only legally certified electoral votes. Respondent claims this position is supported by the historical record. The deception inherent in this claim, however, is demonstrated by the repeated changes in the portions of the historical record on which defendant has purported to rely in his ever-evolving effort to paper over the patent falsity of his reject theory. In the memos, respondent cited only electoral counts of 1797 and 1801. In his September 22, 2022 response to the State Bar's investigation letter, he cited the records of Federal Convention of 1787. In his November 14, 2022 response to the State Bar's investigation letter, he cited 3 additional vote counts, those taken in 1789, 1857, and 1961. At trial, he added the electoral counts of 1817, 1821, and 1837, despite admitting that he had not had a chance to look at the last 2. Then on the 23rd day of trial, respondent claimed that the, quote, most important evidence in the historical record, end quote, was the records of the 1787 Federal Convention. Admitting, quote, I can't say I looked at all of it before January 5th, but I looked at a significant sampling of it, end quote. This ever-evolving set of purported support demonstrates increasingly desperate and dishonest trial tactics. Indeed, a review of the evidence shows that the respondent, an experienced constitutional law professor with asserted expertise in election law, could not have believed that any of the historical events respondent has at various times cited actually supported the January 6th strategy. So there you go. Yeah, we're not going to go through those, but I definitely invite you to. But it will just, it will kill you slowly. Misleading a court. This is the December 31 complaint in Trump v. Kemp. On December 31st, 2022, 3 weeks after full hand recount had confirmed, a full hand recount had confirmed the results of the election in Georgia, and just 6 days before the joint session of Congress, respondent filed Trump v. Kemp, a federal lawsuit seeking an emergency injunction decertifying the 2020 presidential election in Georgia. The complaint incorporated by reference the complaint and appended exhibits filed in Trump v. Raffensperger, a pending state court matter as to which respondent had provided legal advice. According to December 31 emails exchanged among respondent, his co-counsel in the case, Kurt Hilbert, and other members of Trump's Georgia team, they believe that having the case pending, quote, might be enough to delay consideration of Georgia, particularly if Pence has the legal ability and will to insert himself at least enough to win delay, end quote. Respondent's complaint included and incorporated by reference multiple allegations respondent knew or consciously ignored were false and misleading. First, it alleged that Georgia election officials allowed an outcome determinative number of unqualified voters to vote based on affidavits from Brian Geels, Matt Brainerd, walking penis tip, Mark Allen Davis. Let's see. Where's crime fraud exception? Allegations, Geels. Okay, we got through those. The Brainerd. Allegations purportedly supported by the Brainerd. This is Matt Brainerd is an operative in right-wing white supremacy and gross
CNP.
movements.
He's
CNP. Thank you.
Mm-hmm. No,
Included that Georgia, please, yeah.
You're correct
Georgia election
about the other
officials
part.
allowed, yeah. Oh, and those. Yes, and. Allowed at least 1,043 individuals to vote who had registered at a P.O. box, church, or courthouse rather than their residence, and allegations purportedly supported by the Brainerd affidavit included that the Georgia election officials allowed at least 40,000 individuals to vote who had moved across county lines. Brainerd's lack of qualifications and unreliability were evident from the face of the filing. See, I'm telling you, they drink their own Kool-Aid. Moreover, by the time of respondents' December 31 filing, the trio's conclusions had been discredited by December 14th, and 15 declarations filed in Trump v. Raffensperger of Charles Stewart, an MIT political science professor with expertise in election administration and election science, and Chris Harvey, the elections director for the Georgia Secretary of State's office. Stewart concluded that Giles, Davis, and Brainerd, Manny Moe, and Jack relied on database matching procedures, quote, that are known to be unreliable and produce a preponderance of false positives. The anomalies Giles uncovered were either benign errors not indicative of fraud or suggested errors of analysis or ignorance of Georgia law, which was proven. And finally, that Giles drew unfounded negative inferences from the decline of ballot rejection rates. That's right. Harvey likewise undermined the accuracy of the conclusions, citing concerns their data and their assumptions. At trial, Eastman claimed he had, quote, likely read the Stewart and Harvey declarations prior to December 31st, but he dismissed their significance, cavalierly contending that they were simply part of the, quote, adversarial process, and further that the allegations at issue, quote, had the necessary caveats, okay, everybody, to make all the statements true. You know, that up to and including and maybe as much as, you know, all those things that make everything true that I say. I didn't lie. I just fudged. Let's see. The email does show that he understood there were misrepresentations in the filing. Well, Brainerd has a higher level of education than I do. So, you know, there we go. Oh, is that what we call him now? A political consultant? That's interesting. Yeah, he's an idiot. Okay, here we go. Copying the team to advise him that Hilbert had removed numbers from the verified complaint as requested. At 11:15 a.m., respondent wrote back to Hilbert, dropping the rest of the team, stating in relevant part, keeping Bruce and his team off this for the moment. Here's the issue. The complaint incorporates by reference the state court challenge. Although the president signed a verification for that back on December 1st, he has since been made aware that some of the allegations and evidence proffered by experts has been inaccurate. For him to sign a new verification with that knowledge and incorporated by reference would not be accurate. Several hours later, in an email to the full team, Eastman and Hilbert agreed to insert a footnote in the verified complaint and Trump's verification support disclaiming personal knowledge of the facts and figures therein without changing the allegations. Oh boy. At trial, respondent insisted that the allegations were accurate because, quote, in every instance, Mr. Brainerd and Mr. Giles' affidavits are caveated with as many as or based on information contained in the records. This statement typifies respondent's efforts to disregard the truth and underscores his dishonesty. This is the suitcases of ballots. In fact, respondent knew when he filed Trump v. Kemp that these claims had already been investigated and debunked by state election officials. He conceded at this hearing this year that the ballots under the table were not hidden, as alleged, but were just regular absentee ballots in a processing container, and that he has no evidence that the ballot workers were processing fraudulent ballots. Furthermore, as he knew, Georgia law does not require poll watchers to be present for the canvassing. It simply permits them to be. Thus, even if his allegation that observers were told the operation was closing for the evening were true, it does not follow that the ballots counted at that time were illegal, as he dishonestly implies. Third, the complaint alleged that the Georgia election officials engaged in illegal signature verification process by virtue of abiding by a March 2020 settlement agreement, which was also false and misleading, as the respondent knew but did not disclose in Trump v. Kemp. On November 20th, 2020, the district court had denied a motion for temporary restraining order predicated on the exact same allegations more than a month earlier in Wood v. Raffensperger, concluding that the settlement agreement is a manifestation of Secretary Raffensperger's statutorily granted authority. It does not override or rewrite state law. The 11th Circuit affirmed. 11th Circuit. Who's in charge of the 11th Circuit? Anybody? Clarence Thomas. Affirmed on December 5th. On January 5th, 2021, the district court denied the requested injunctive relief in Trump v. Kemp. January 5th. Oh, here's his appearance on the Steve Bannon radio program. Yeah. So on January 2nd, he went on the War Room. Well, that's a typo. To podcast to advance the January 6th strategy. Bannon, who was in regular contract with Trump during this time, and that is footnoted as, January 3rd White House phone log, reflecting calls to and from Bannon at 10:11 a.m., 9:53 p.m., and 10:43 p.m. January 5th White House phone call log, reflecting calls to and from Bannon at 8:57 a.m. and 8:31 p.m. And the missing logs, I'm just going to say. Bannon, who was in regular, introduced Eastman as the president's constitutional lawyer and asked him, quote, "You're the lead sled dog here. What should people be looking for?" Respondent replied, "They ought to be putting pressure on their state legislators. So if you're in Georgia or Pennsylvania or Wisconsin or Arizona, call your legislators. Demand that they call themselves into session and then either decertify the existing slate of electors if there's just too much uncertainty about the results of the election, or certify the correct slate of electors if the number of ballots that are shifted, if you get rid of the illegal ones, are enough to affect the outcome, as we believe they are. So pressure beginning now. Rolling thunder pressure. If you find one guy saying, well, I can't do anything, the leader is the one blocking it, and shift the focus to the leader." As grounds for this rolling thunder pressure call to action, respondent claimed the existence of massive evidence that the election was conducted by partisan elected officials and partisan judicial officials in violation of state statutes, resulting in more than enough absentee fraud to have affected the outcome of the election. But respondent did not have massive evidence of absentee fraud. When pressed at trial for the basis of this claim, respondent cited the, quote, weakening of signature verification rules in Georgia and Pennsylvania, claiming they, quote, caused a dramatic decline in the disqualification of ballots. But the evidence trial showed that neither respondent nor his experts had even sought to ascertain the number of absentee ballots rejected on signature verification grounds, something they could have easily done using publicly available information, according to Grimmer. As to several other swing
It kind of
states,
sounds like they're saying groomer.
sorry, Grimmer, like Brothers Grimm. But he could, oh, never mind. Okay. On the night of January 1st, before his appearance on Bannon's podcast, the respondent emailed Trump advisor Boris asking, quote, has anyone identified state laws in January 1st? Has anyone identified state laws in Michigan, Arizona, and Nevada that were violated? When confronted with this email at trial, respondent said, quote, I vaguely knew of things. I was not involved in any of the litigation in Michigan, Arizona, or Nevada. On the morning of January 2nd, respondent sent another email, this time to another attorney, asking for help in identifying violations of state election law in Michigan, Arizona, and Nevada. To the extent violations are clear, can you let me know this morning what, if anything, went on in Michigan that fits the bill? When confronted with this email at trial, respondent explained, I had been vaguely aware of allegations of illegality in all three of those states, but I didn't have the particulars. Okay. Let's just make sure we didn't miss anything juicy. Here we go. Oh, here we go. On October 24th, 2023, respondent attempted to calculate the number of votes in Georgia affected by the changes to signature verification and testified that, quote, 6,500 votes resulted from a decline in the rejection rate. He reached that number by applying the signature rejection rate to the roughly 5 million votes that were cast in Georgia. That's his quote. An enormous miscalculation, because 74% of those ballots were not verified by signature. Respondent's erroneous belief that all ballots in Georgia were subject to signature verification reveals his conscious disregard of Georgia election administration, and his failure to consult a real expert on this issue reveals that he had no serious interest in learning the actual non-material effect of changes to signature verification. I mean, boom, boom. It's just like it's a dick slap. Boom, boom, boom. It's the hot dogs on the face. Boom, boom, boom. California. You rock. December 3rd, testimony to the Georgia Senate was just the first of several presentations. That's part of his Rolling Thunder. On January 2nd, he joined Trump and other allies as a featured speaker at a national briefing for several hundred legislators to solicit legislators' signatures on the January 5th letter to Pence demanding he delay certification. During the briefing, respondent urged legislators to, quote, insist on enough time to properly meet, investigate, and properly certify results to ensure that all lawful votes, but only lawful votes, are counted. January 3rd, and he participated in a similar call with state legislative leaders from the 7 states. The agenda shows its purpose was to obstruct the electoral vote count on January 6th. Quote, we need Congress to pause the vote counting on January 6th. Alternatively, we need state legislators to pause, or decertify their certification of electors before the count on January 6th to prevent the Congress from certifying anyone with 270. We must have 37 electoral votes on pause, decertify, to pause, drop Biden below 270. I need to take a minute here and take a soda break. Oh.
You can go do the whistleblower thing I sent you if you want.
Yeah. Oh. Yeah. Was that the last one?
I think it says whistleblower.
Oh, is this the Tony Schaefer? Is it the Tony Schaefer tweet?
Yeah. But it's about the it's about the one you read about earlier. The guy with the truck thing.
Oh, the truck guy. Oh, okay. Hold on. Here we go. Oh, this is the Jesse. Oh, wait. Am I showing that? I'm so sorry. I'm an idiot. Am I showing? I'm not showing the right thing. I'm so sorry. Hold on. Okay, wait. There we go. Here we go. Sorry, everyone. Phil Klein. Oh, boy. Tony Schaefer says his team at the London Center for Policy Research has teams assisting the Amistad Project. Phil Klein says they have a man who will tell the truth about what that load is.
Jesse, Colonel Schaefer is going to demonstrate how we made an estimate of the number of ballots that Jesse had in his load on that occasion. And I want to remind you, we've received corroboration, not from Jesse, but from others, that this happened multiple times from that particular facility. Colonel?
But we don't have any evidence of it. Is that Jesse? Oh, there's Tony.
Thank you for the
Spooky
honor
monkey.
leading this investigative team. And as we speak, we have members.
Tony
of our
Schaefer
team
also
involved
got
in
us all
continuing
knocked off Twitter
operations.
once.
I think it's a reasonable question, one that I think any reasonable American who's curious about 24 pallets of ballots, where they went. So we have a number of teams supporting the Amistad effort. One of them is my own London Center intelligence team. They did the estimate of ballots. And we'll be continuing to take in, we'll provide information later regarding where you can email leads to as well. We'll put that later. Yeah.
Okay, we've got a few more things, and then we'll get to questions and also mailing in leads. Thank you, Colonel. And they picked the wrong man. Because here you have a man who's willing to tell the truth about what that load is.
Wait. What was his there? How did they? If you're not familiar, oh yeah, this
I
is
think
a good
you
one.
needed to go up one.
Oh, okay.
I
Sorry.
think you skipped the other one. Go up.
Oh, up in your. Okay, hold on. Hold on. I know what you mean.
I think it was the one above that.
Oh, the whistleblower. I see it. I'm so sorry. Okay, here we go. Share this sound. There we go. There we go. There we go. Sorry. Okay, back it up a little bit. December 1st, 2020, press briefing, Amistad Project of the Thomas More Society. Phil Klein hosted a press conference there's another name we need to hear more about. Press conference outlining some evidence they uncovered, quote unquote, from the 2020 election. They had a little trouble with the props, and apparently Phil Klein is an asshole. Which is true.
My name is Phil Klein. I'm the director of the Amistad Project of the Thomas More Society. And I appreciate your attendance and I look forward to your questions today. First, let me give a little preface as to what the Amistad Project and the Thomas
Why
More
do they call it
Society
Amistad?
has been involved in over the last several months. The Amistad Project started looking into election integrity about 18 months ago. Through that process, we have developed attorneys that are in virtually every swing state that are working on our behalf. And additionally, we have investigators that have been involved in the field for several months, developing evidence as it relates to the integrity of the 2020 election. And it will lead up to Jesse Payne's story. Jesse Morgan. Jesse Payne was a prosecutor who worked for me. I'm sorry, Jesse. Thank you.
That's not his name.
Let's look at the blood in the street. I'm taking you over to our lawsuits right over here. These are lawsuits that we have filed. This one is in Pennsylvania. Thank you, Peter. And if you keep it, yeah, you're bringing it up? Thank you, so I can see it. What you have right here is a chart of several charts, in fact. That's okay, buddy.
He dropped them all.
Georgia. This is our experts.
I played that like over and over to myself. I was laughing so hard.
To listen to what this man says.
Yes.
Because he is a
Strength for your meeting.
Teller. Jesse?
Yeah, Jesse, tell us all about it.
Thanks, Phil.
Looks like Forgiato Blow.
Tell you what, first time I met him, I was like, this dude's pretty cool. And then afterwards, I was like, this dude's an asshole.
Oh.
Best clip ever. I can't believe that didn't go anywhere. It was so fucking funny. I was like, hey, you know, it's because we're cool. And then I was like, oh, fuck that. He's an asshole.
That's an asshole.
My name is Phil Klein.
Which is not untrue. He was right. Just turns out Jesse was right. Oh my God. I can't. Fresh hellscape. We're in the constant hellscapes. I want to go to some of these other ones. What is this one? Let me go. Oh, the Roger Stone stuff. Oh, Jackie Bingo. Oh, those are crazy.
Oh yeah, so that one is like that. Just because we talked about 2000 and and then the recent news about how Jack Smith is going to basically use, the fact that they were talking about starting a riot, I think, in Michigan or something. I think it's the new unindicted co-conspirator conversation that was happening, and they were talking about the riot. Well, I only sent that to you because if we talked about it 2018, you see the same exact people. If you went through that thread, it's so clear who done it, who schemed it. It's just so easy to see,
because
Jackson Sovic, Ali Alexander, Laura Loomer, Matt Gates, Jacob Ingalls, Roger Stone, Mike Cernovich, all listed down. It's all the same.
All the names that we're not hearing enough, but I don't know. It's going to be a wild couple of years. Okay, let's continue. Let's see, and I may have to close off at about 45 minutes just to run an errand this afternoon that I think I need a little bit of lead time for, but we'll get through as much as we can. And then I really want to keep doing this, Gal. If you, not necessarily marathon, but I want to schedule more time because I think the data
we got to do some transcripts,
right? And then the data, I have so many documents lined up for us to, I can't even tell you. And I'm sure you have others, but we need to figure that out. So actually, I think what I'm going to do is I'm going to go ahead and close it down now. I want to run this errand and get it over with. And then, because we've absorbed a lot today in our 2.5 hours. But I definitely want to schedule more time to do this again. And I don't know if we want to even spend the lounge time on it. Anyway, I'll connect with you, Gal, on our usuals, and we'll go over. But I really would like to, and we have Eastman's response to this, or response, and Oomph also went over Eastman's response. So
What
we're
did
going to take
she
a look at his.
ultimately conclude? Like, if you jump ahead, like, what's the kind of, what was the conclusion on this? Like, what was determined?
Oh, this
or
is not
whatever?
hers. No, this is actually the state bar lawyers. This is their case in summary. So
Oh,
sorry. This is not the court's decision. It is the briefing that the state bar attorneys put together.
oh,
So
okay, that makes a lot more sense. I'm
I'm sorry.
literally
I
dying to
think I'm
see
misleading
hers
you.
because I was kind of thinking as we were reading it, like I was a little disappointed because I expect her to be a snarky bitch. Like I
Oh,
expect
I
it to be
cannot
fucking
fucking
fire.
wait.
I
Like
can't
there
wait.
needs to
Yeah.
be a red carpet event when her opinion comes out, because I think just based on what she said in court, it's going to be fucking insane. So I have no doubt
Yeah,
that
she's gonna tear
it's
them
going to be a
apart.
good read.
It's gonna be
She is going to tear
amazing.
them apart. This
I
is
can't
really
wait.
just, to me, this is a beautiful layout of his crimes and his bullshit responses to those crimes. And that, I think this is required reading if you're going to pay attention to Georgia or anything else that's going on. So that's why I think it's still important. And we actually are making pretty good time. We a little more than halfway through the document, and there's probably a lot of exhibits and shit like that. So in fact there is, I can see. So I will go ahead and confer with Gal et al. About another time, and let's see if we can drag Joe into this too, because I'd sure love to hear Joe Dempsey's take on these documents, and I know he's been looking at them as
Yeah,
well. So let me ping
yeah,
Joe too and see if we can schedule part 2. All right.
that'd be great.
Oh, ladies and gentlemen, Gal Suburban, everybody, clap, clap. Snap, snap, snap.
Whee!
Thank you, Gal, for taking time during your day. I know you got a lot of stuff going on. And we will see everyone later on. Thank you to Oomph for doing some heavy lifting on this early on so that I could get my sea legs a little bit. I really appreciate that. Always appreciate his take on these things. Super smart people. We just love smart people. No, don't go. It's never anything you say. We love you. We love you. All right, my loves. Have a great rest of your Thursday or Friday if you're GP, and I will see you later. All right. Goodbye, gal. Boop. Let's do a little bit of music to take us out. Oh, how about this? Yay! Oh, it's Thursday. I think you're really awesome. I think you're really awesome. Dooba dooba doo.